Ladies and gentlemen, one more moment, and then we will get started. All right, friends, good evening. We are going to begin. We are here for the next round of this year's Summit Cup tournament. May I have an entry of appearance first from plaintiff?
Yes, Your Honor. If the chat function is working, my co-counsel can tender that document to you now.
Super.
I think it was disabled in our round last night, so that might not be feasible, but, oh, did it go through? Perfect.
I see that document, and I will download it. You are muted. Okay, at any rate, am I correct that counsel for plaintiff are Corey Posey and Rachel Maxwell? Now I can see the document. That's plaintiff. And forgive me as I make my own handwritten note. All right, thank you for that. May I please have the same from counsel for the defense?
Yes, Your Honor. We've been having some technical difficulties getting those things across. So if it's okay with Your Honor, we would just like to introduce ourselves over the chat function on here, over the webcam, if that's okay.
That is fine, but to put everybody on an equal footing, then we'll do it all live. Yes, so let me start, and that please, that's not held against anybody. You know that. Okay. Let me hear formally in court an introduction from the two counsel for plaintiff, and your team name is Mount Bedford. Counsel, will you introduce yourself, please?
Yes, Your Honor. My name is Rachel Maxwell. That's Maxwell, and along with my co-counsel, who seems to be having some technical difficulties. So I'll tell you that her name is Corey Posey, and that's spelled P-O-S-E-Y. And we represent the plaintiff in today's case.
Got it. Ms. Posey, why don't we try once more to make sure we can get your mic working before this begins?
So I have a different mic that I'm using. That's the issue. Let me see if I can get it replugged in here and see if.
Okay, we'll take it. That's lower volume. You may have to raise the volume on it.
I guess we're foregoing that mic.
And actually, it sounds fine now. I think.
Oh, was it? How about now?
Thank you so much. And I'll now ask that you both mute yourselves. And for La Plata, and that's the defendant, will you kindly introduce yourselves?
Yes, Your Honor. My name is Matthew Hobbs, and I, along with my co-counsel Jordan Arroyo, will be representing the defendant, Ms. Karen Beja, in today's case.
Okay, you are both welcome as well. Let me just write those names down. All right.
And Your Honor, I believe that the expert witness for the defense might be in the waiting room for the Zoom call.
I will check the waiting room again right now. Thank you for that heads up. Is that, yes, we have a person there, and that person is now admitted. So I probably should ask, are all witnesses who are supposed to be here now?
Yes, sir. I believe, yes, Your Honor, I believe so now.
Okay. And obviously, witnesses, until you're testifying, we'll ask that you kindly turn off your video and, of course, keep your microphone on mute. All right, so we have everyone in the room. I need to ask the scoring jurors the following question. Do you know anyone on either team to a degree that will affect your ability to provide an unbiased evaluation? May I ask our scoring judges unmute and tell me if there is a problem? I'm hearing no problem, so that means we are going to proceed. I am asking that everyone please raise their right hand. Please indicate by saying "I do" at the end of this if you swear to abide by the rules of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I do.
Thank you, everyone. Members of the court, or the members of the bar, I am now calling case number 082263, Cam Donaldson versus Karen Beja. I am the presiding judge. My name is Judge Epstein. Counsel, are there any housekeeping matters to which the court needs to attend? I will start with counsel for plaintiff.
Yes, Your Honor, we do have a few preliminary matters. Before we get started on those, would you like a brief recitation of the facts?
Nope, all I'm asking for at the moment is housekeeping.
Perfect. Then, Your Honor, due to the unique circumstances of the trial today, with us not being able to show our exhibits to you or provide you with courtesy copies, we confirm that you do have a copy of those documents.
I have everything I need, thank you. And I understand the markings and I'm familiar intimately with this file.
Perfect. Would Your Honor be okay with us referring to those documents by the last two numbers of the Bates number at the bottom right-hand corner of the page?
As long as everyone is on the same page, so to speak, that's fine. And I'm seeing head nods affirmatively, so if that's what you all are doing, that's terrific.
Your Honor, the plaintiff would also ask for the court's permission to enter evidence during opposing counsel's case in chief due to the fact that we can't call rebuttal witnesses in today's proceedings.
That should, yes, in other words, if the exhibit is properly marked, you can move it even though it's in their case. Fair point. Got it.
And plaintiff would also request to know how Your Honor prefer that we handle objections. Should we assume that constructive sidebar has been taken, or should we request that sidebar before arguing the grounds?
I don't know that you'll always want a sidebar. As long as you say sidebar or words to that effect, then we will immediately be constructively at sidebar.
Thank you, Your Honor. And with that, we're ready to move on to motions in limine.
Well, let me check with the defense. Are there any housekeeping matters for the defense?
Yes, Your Honor. Very briefly, I know that we're in a different situation here with what's going on in our country right now with the virus and everything like that. So we just want to make sure that we're still able to show deference to the court. So we just ask Your Honor's preference whenever we're addressing Your Honor. Do you want us to stand? and perhaps maybe a few moments between witnesses or between attorneys if we need to move some things around like that, if we can have that permission.
Well, let's take that in reverse order. At any point, if you need a moment or two to adjust, you simply request.
Yes, Your Honor.
As to addressing me, I leave it to each of you as to how you wish to proceed, standing or seated. I know some people have cameras that that allow both, some don't. So whatever your approach is consistent with your technology, I will understand if you're only seated that could be a technology thing. It doesn't matter. But thank you for asking.
Yes, Your Honor. And with that, the defense is also ready to proceed to motions.
Very good. Then it's my understanding each side has 4 minutes and is allowed a maximum of 3 motions. We will follow in the orderly procedure since plaintiff has the burden. Plaintiff, you may present your motion or motions in limine. Thank you.
Your Honor, the plaintiff moves to exclude any mention of the police investigation into the victim, Mr. Donaldson's disappearance, pursuant to Rules 802 and 701C. By way of background, the police still have an active investigation open into Mr. Donaldson's whereabouts, and we anticipate that the defense may try to enter testimony pertaining to this investigation, particularly the reasoning that police did not take the defendant into custody. This testimony would go to the conclusion that the police reached and the reason behind those, and would therefore be an impermissible inference. Furthermore, nobody that was involved in that investigation is testifying today, so it would constitute inadmissible hearsay with no recognized exceptions.
All right. Counsel for the defense, do you agree or do you oppose?
Yes, Your Honor. We're going to oppose that motion. May I be heard?
That's why I'm turning it over to you, sir.
Yes, Your Honor. We believe that we will have an expert in today's case who will qualify under Rule 702 and be able to testify to some of the things that opposing counsel just mentioned. Dealing with the 701 first, we believe that that expert will be properly qualified and will be able to testify to things that would fit inside of what opposing counsel just mentioned. And in responding to the hearsay objection, we also believe that all of those statements and all of those reports that were received by that expert will be used for that expert to come to their conclusion. So it will be effect on the listener. So we would simply ask that either the court deny that motion at this time or that the court reserve judgment until that expert is tendered.
So I just have one question, Mr. Hobbs. I've got that you have an expert, but I have no idea what you would ask that expert about any of this. So give me a 2-sentence, our expert would say, so I can understand at least what's going on here.
Yes, Your Honor. Our expert would say that as part of his job in investigating insurance claims, he has contacts within the police department that he uses, especially whenever investigating any sort of wrongful death or any sort of life insurance claim, as foul play would be at issue when determining whether to pay out those claims or not.
All right. I clearly cannot decide that now based on the little I've heard. So I will hold that under advisement, but it is not to be mentioned, which means not in openings. And when we reach the point in the trial where you feel it is appropriate, you may ask for a sidebar. So that's HUA for the first motion. Ms. Maxwell, was that it, or do you have anything more?
I have one more motion, Your Honor. The plaintiff moves to exclude any mention of the fact that the victim in this case's pilot's license was suspended at the time of his disappearance, pursuant to Rule 802. Many of these witnesses have indicated that Mr. Donaldson's pilot's license was suspended at the time of his disappearance. And because this suspension would have been ordered by an administrative body, and no member of that body or document that can show that that suspension was ordered will be presented in court today, this is inadmissible hearsay with no recognized exception.
Who do you anticipate would talk about it?
I anticipate that the defense might try to bring in this information to go to the fact that Mr. Donaldson—
Through who? I'm sorry, Ms. Maxwell, I didn't mean to be rude and I apologize. Through who? Through what witness?
Through either the plaintiff or the defendant in this case, and perhaps the experts, because they would also be aware of this fact.
Okay. Mr. Hobbs, are you handling all the motions?
No, Your Honor. I believe my co-counsel will be handling.
Hi, okay, your turn.
Yes.
What's your position on this? Did you intend to bring up something about a suspended license?
Yes, Your Honor, we are going to oppose that motion. By way of brief background, Lou Donaldson, the decedent in this wrongful death case, owned a number of planes that were not thoroughly investigated by the private investigator and were not considered by the plaintiff when he was bringing this case. These are not going to be hearsay statements as to the contents of it, but Cam's personal knowledge about what was going on. He will not be going into the actual details of the suspension, but simply the fact that he was aware that his father's license was suspended at the time. This is highly relevant as well, Your Honor, as to elements 2 and 4 in today's case.
Ms. Maxwell, the last word. Can't a child say my dad's license is suspended?
Your Honor, I would argue that that knowledge would be based on hearsay, and whether or not it goes to the defense's point, it still wouldn't get over that hearsay, barring it.
Assuming that there is a foundation laid that Cam is pretty close with their father, the objection is overruled. But Ms. Arroyo, I need that connection made.
I'm sorry.
We'll need that foundation.
Your Honor, I'm more than happy to lay that foundation.
Great. Okay. So those are my rulings. Is that it, Ms. Maxwell, in terms of plaintiff motions?
Your Honor, we're ready to move on to opening statements after defense goes.
All right. So let's hear from the defense. Are there any defense motions? You don't have to, but you're entitled.
Yes, Your Honor. We have two motions that we'll be making before the court. I'll be making the first one. I know Your Honor just said that previously you would not like a brief recitation of the facts. Would Your Honor like that at this time or no?
If you think it's important for me to understand your motion, then please go ahead. I did not need that for housekeeping.
Yes, Your Honor. So one of the witnesses in today's case that has been deemed unavailable, according to 804A, is a person by the name of Exotic Bob. However, we believe that the testimony that might be brought in would not fall under any of the recognized exceptions under 804B, nor any of the other recognized exceptions under 804 or 803, and therefore we would object to both hearsay and hearsay within hearsay to any and all of that testimony coming in today, and attempt and seek to bar that completely from today's trial.
So, Mr. Hobbs, I do need some help here.
Yes, Your Honor.
Where or when did this wonderful person named Exotic Bob testify?
Yes, Your Honor. I believe that it was part of a music video, and we have a transcript of that music video today. However, that music video and the contents therein was not any sort of sworn statement or anything that would qualify it under 804B exception.
Okay. So there's a music video where Exotic Bob, who is now unavailable, said something, and you're moving to exclude the something. Who is responding?
I am, Your Honor.
Thank you, Ms. Maxwell. Go ahead.
So to address the first layer of hearsay in this exhibit, Exotic Bob is an unavailable witness pursuant to the stipulations, and these statements in the video are statements against interest, and so they would fall under the exception to allow them in.
What are they, so that I can tell if they are indeed declarations against interest? And are they against financial interest, penal interest? What kind of interest?
It would be penal interest, Your Honor, because he admits to being in a highly illegal deal with the defendant in this video and talks about their interactions during that deal that they were in together. And so this would be a statement against his interest in that way.
What did he say?
He says that he and the defendant are engaged in a highly illegal exotic animal trade. They work together in order to try and get exotic leopards and lions, I believe, smuggled into the country illegally.
So the statements are, I and Ms. Bazia did a wild animal illegal business.
Yes, to paraphrase that, you're right. I didn't exactly quote it, but yes, Your Honor, to that effect. And then he goes on to also elicit statements that the defendant made at that time, which would be the second layer of hearsay and would be party opponent statements.
And the music video is or is not under oath?
It is not, Your Honor.
So we're just going on the declaration against interest.
Yes, Your Honor.
What about that, Mr. Hobbs?
Yes, Your Honor. According to 804B3, a statement against interest must have a tendency to expose the declarant to civil or criminal liability. It is the understanding of the defense today that Exotic Bob is already serving time for the exact thing in which plaintiff's counsel is saying that he would be exposing himself to that civil or criminal liability for. So therefore, because of that, the exception doesn't apply, as he is serving time for the very thing that they are saying would be a statement against interest. He's already in jail for that crime, Your Honor.
Was he serving time on the day he said it?
Yes, Your Honor, he was.
Is that agreed, Ms. Maxwell, or not?
Your Honor, he is serving time at the time he's making this video from prison, but there's no evidence to suggest in this video that it is for the crime that he is speaking about. Honestly, the words that he says sounds more like it was an additional act and not something that would be the exact same crime that he was talking about.
Mr. Hobbs, I have to tell you that my recollection is that we don't know exactly what Exotic Bob was in jail for on the day he said it. With that in mind, and because of the layering of the hearsay, respectfully, sir, that motion is denied.
Yes,
So,
Your Honor.
subject to relevance or other issues, but on the hearsay issue, the recording or excerpts therefrom are admissible.
Yes, Your Honor.
Okay, second motion.
Your Honor, I'll take up that second substantive motion before the court today. By way of brief background, this is a wrongful death case. We have reason to believe that plaintiff will introduce evidence about Mr. Lou Donaldson's will to show that it's more likely that Miss Beja was somehow involved in his disappearance. One of the witnesses on that will is named Samantha Lane. She will not be here during today's proceedings. There are two ways by which Miss Lane's testimony could enter in before today's tribunal. The first way is through a phone call conversation between Miss Lane and the plaintiff's hired expert. And the second way is through a letter that is purported to be written by her, but that cannot be confirmed to be so. As to that phone call conversation, we object to hearsay, hearsay within hearsay, and 403. And as to the letter, we object to hearsay, 301 burden shifting concerns, and 403.
Wow. Okay, response, please.
Your Honor, regarding the first instance of statements that might come in, those statements made to the plaintiff's witness, Investigator Pride, during that phone call, we intend to tender this witness as an expert in forensic document examination. And because he relied on these statements to come to his conclusion about the validity of the will in this case, I intend to lay the foundation so they'll be able to come into evidence under 703 as the basis of an expert opinion.
That's not for the truth of the matter asserted, is it, Ms. Maxwell? That's
No,
just
Your
as background.
Yes,
Are you limiting your use to background?
To background, yes, Your Honor. And then regarding the other instance that they referred to, which would be the letter that was sent to their witness, Investigator Renard, we don't intend to use this for the truth of the matter asserted. This goes directly to the credibility of this witness because he received this letter, which indicated that Miss Lane had not, in fact, witnessed a signing of this will. And because he was investigating the validity of this will, his failure to follow up on that letter goes directly to his credibility and the thoroughness of his investigation.
Again, are you using it for the truth of the matter asserted or to attack the sufficiency of the investigation?
The sufficiency of the investigation, sir, not for the truth of the matter asserted.
So with that understanding that none of this is coming in for the truth, my ruling is that is admissible for the limited purpose of attacking the investigation, assuming that you can link it up in some way to make that logically relevant. So I want to make sure we're clear on my rulings and that I am clear on my rulings. The police investigation held under advisement, no mention without coming to sidebar. The non-licensure or suspended licensure admissible as long as we know that the relative of the deceased has a sufficient basis for saying that. The Exotic Bob conversations, admissible. And this last one, admissible not for its truth, if it's appropriate to be challenging the investigation. Is everyone clear on those rulings?
Your Honor, just to clarify, those statements that you just ruled were not admissible for the truth of the matter asserted. May my co-counsel mention those in her opening statement?
Yes, I mean, subject to, of course, that if somebody doesn't link this up, but that's true with any piece of evidence. You mentioned it at your risk, but I'm assuming you folks are going to be able to bring it together. The
Yes,
only thing that cannot be mentioned is something that I excluded or held under advisement.
Your Honor,
Yes.
just briefly, as to the last matter surrounding Samantha Lane, they were able to tackle the hearsay issue, but they still have not tackled the 403 concerns and the 703 concerns, because even though this expert is able to testify as to his expert opinion, they still must show that it's substantially more probative than prejudicial. May we still object to the admission of Miss Samantha Lane later on in this trial as they begin to bring her up? Is she still subject to those objections?
That's a fair point, and I apologize. I should have resolved that. So what you're saying is, even if it was reasonable to be relied upon under 403, the jury might misuse it for the truth of the matter asserted, and therefore we have a problem. I'm going to rule now, notwithstanding that, and I will give an appropriate limiting instruction. It comes in for the limited purpose, and if the expert needs to use that to explain their opinion, they may.
Thank you, Your Honor.
And thank you, though, for making sure I get everything done. That's so important. All right, we are ready for openings. I will ask that everyone mute themselves and turn off their cameras except the party giving the opening. Obviously, if there's an objection, the responding person can immediately unmute. Are we ready for opening statements?
Yes, Your Honor.
Ms. Posey, you may proceed.
Before I begin, Your Honor, I just wanted to let you know I'll need a minute to set up the well, and just put opposing counsel on notice as well that my camera will be off when I come back, so not to distract her when she begins.
Thank you.
Your Honor, can you hear me okay?
I can. I will ask if any one of the attorneys cannot hear well, please immediately unmute and tell us now, or my scoring judges, if anyone is having trouble. I will tell you it is a little low,
Okay.
but I think I can raise my volume here to listen.
Testing, testing.
Counsel, you may proceed.
May it please the court, counsel, members of the jury. We are here today because Lou Donaldson is not. Lou Donaldson is not here today because his wife, the defendant, killed him and forged a will, declaring herself the sole heir to his fortune. Today we are here because Mr. Donaldson's daughter wasn't just deprived of her inheritance. More importantly, she was deprived of her father. And since there's nothing we can do to bring her father back, Miss Donaldson just wants what rightfully belongs to her family. And she wants the defendant to be held liable. Good evening, members of the jury. My name is Corey Posey, and I, along with my co-counsel, Rachel Maxwell, have the privilege of representing Mr. Donaldson's only surviving child, Pam Donaldson. Now, before we get to exactly what happened to Lou Donaldson, let me tell you a little bit about him. Lou Donaldson started from the bottom. He had little formal education, but an excellent will to succeed. He began his career in sales, eager to earn money for what he was truly passionate about. And he did it. Lou Donaldson opened the Wild Wildlife Big Cat Sanctuary, and he went from sales to rescuing wildlife. Lions, tigers, leopards, you name it. Mr. Donaldson had a soft spot for these big fluffy creatures, and he shared that love with his daughter. Miss Donaldson followed in her father's footsteps, and she joined the family business, and for 20 years, she was by her father's side at the Big Cat Sanctuary. They even joked that she knew his business better than he did. Life was the cat's meow for Mr. Donaldson and his family. That is until the defendant came prowling into their lives. You see, late one evening years ago, Lou Donaldson was driving down the road, and he notices a lovely young hitchhiker. He becomes curious. Who is this beautiful woman? What is this woman doing all alone out on these streets so late at night? His curiosity leads him to offer her a ride, and it turns out to be love at first sight. But members of the jury, as the saying goes in this case, curiosity really did kill the cat. Now, Mr. Donaldson marries the defendant, and for 11 years, he shares his home and his wealth, and even the Big Cat Sanctuary with her. But you will learn that things took a turn for the worse. And the couple began arguing so much that Mr. Donaldson decided he wanted a divorce. In fact, you'll learn that things got so bad, Mr. Donaldson filed a restraining order against the defendant. The defendant could feel her husband's wealth and those big cats who she'd come to adore just slipping through her fingers. And then 2 months later, Mr. Donaldson was seen alive for the very last time. On August 17th, 2012 at 6 p.m., Mr. Donaldson packed up his things to leave the office at the end of another Friday, and he yells over his shoulder to his daughter, inviting her to supper on Sunday. But little did Miss Donaldson know, that Sunday supper would never come. A few days later, Mr. Donaldson's van was found abandoned at an airstrip 40 miles away. Now, he was an experienced pilot, but you will learn that he didn't store any of his planes at this hangar. And even more suspicious, he was blind as a bat without his eyeglasses, yet his only pair was found in that abandoned van. Mr. Donaldson vanished without a trace, and his body has never been found, but members of the jury, you will learn that the defendant had every means to make that happen. Now, shortly, Miss Donaldson will take the stand, and she will tell you about the devastation that followed her father's initial disappearance. She will tell you how that following Monday morning, she went into work, and the defendant already knew that her father would not be returning. So she fired Miss Donaldson on the spot. Miss Donaldson had been a crucial part of her family's business for over 20 years, and suddenly she was left not only unemployed, but in the dark as to where her father was and to what the defendant did to him. 5 long years go by, and Miss Donaldson receives no answers, but members of the jury, you will learn that all those years, the defendant was just biding her time. You see, legally, she had to wait 5 years in order to declare her husband dead, in order to collect his $5 million insurance payout. And you will learn she did just that. She waited 5 years to the day for her husband dead in filing that insurance claim. And you'll learn that in filing that insurance claim, she turned over what she claims to be Mr. Donaldson's last will and testament. But Miss Donaldson will tell you this was not her father's original, genuine will. Later today, you'll hear from Investigator Taylor Pride. And she will tell you that she's a forensic document examiner, and she reviewed that purported will. She'll tell you that not only is the language of that will suspicious, but Mr. Donaldson's signature was forged. Now, members of the jury, when a will is created, the owner of that will must sign it, declaring that everything stated in that will is the truth, that that is exactly what he wants to happen when he passes away, where his money will go, who will move into his home, who will take over his business. And there must be witnesses to that will. Those witnesses signed the will just the same, saying that that owner did sign it and that he did agree that that was all true. Today you'll learn Mr. Donaldson's will had only 2 witnesses, one of whom was the defendant, the one person who stood to gain everything upon the execution of that will when her husband disappeared. And the other witness later confessed that she was coerced into signing it, that she never actually saw Mr. Donaldson sign his will. The evidence will show that that will was forged, and then it will be your job to decide who would forge that will and why would they forge that will. Members of the jury, all your answers today lie with the defendant. We are here today because Cam Donaldson has brought a suit against the defendant for the wrongful death of her father. And in order for her to prevail, we must prove a few things to you. That Lou Donaldson is dead, and that this is a result of the defendant's conduct. And that Miss Donaldson suffered injuries, damages, or losses as a result of her father's death. And that's because of the defendant too. Now we must prove this to you by a preponderance of the evidence. And this is just a fancy term for saying that something is more probably true than not. We are confident that after you see the facts and the testimony and the evidence today, you will have no choice but to find that the defendant killed her husband and caused all of Miss Donaldson's heartache. Lou Donaldson's curiosity about a lovely young hitchhiker years ago became his downfall. What he expected to be a life full of love and laughter and big furry rescue cats actually became a life tragically cut short. And the business that he worked so hard to build from the ground up, falling into the hands of the woman he was seeking to divorce. A woman who threatened to kill him. A woman who ultimately caused his untimely death. What Miss Donaldson really wants today is her father back. But we can't give that to her because of the defendant's actions. All we can do now is to return to Miss Donaldson what her father intended to give her. And in some small way, hold this defendant responsible for her despicable actions. We are here today because Lou Donaldson is not. The evidence will show Lou Donaldson is not here because the defendant made sure of it. At the conclusion of today's trial, we will ask that you find the defendant liable.
Thank you, counsel. Does the defense wish to open now or to reserve their opening?
Your Honor, I'm going to open now. Permission to please turn off my camera briefly just to set up the well?
Sure.
Thank you, Your Honor. Reality, rumors, and revenge. Cam Donaldson was faced with the reality that her father chose Karen Beja over her. So she started spreading rumors to get her revenge. Because Karen took what she wanted and what she thought she deserved. Members of the jury, my name is Jordan Arroyo. Today, alongside my co-counsel, Matt Hobbs, we have the distinct pleasure of representing Ms. Beja in today's proceedings. For the first half of today's trial, nothing that you hear about Ms. Beja is going to come from her. It will come from her stepdaughter, who hates her, who thinks that she should own wildlife instead of Ms. Beja, and the expert that she hired 5 years after her father's disappearance. So members of the jury, please allow me to be the first to introduce you to Miss Beja. Miss Beja, will you please just turn on your camera for a moment? Members of the jury, this is Miss Beja. She's a widower, she's a hardworking businesswoman, and she is a lover of big cats. She owns the Wild Wildlife Big Cat Emporium. She takes care of lions and tigers, no bears. And when she's not at the Emporium feeding tiger kittens, she's out in courtrooms putting away the bad guys who would do them harm. Miss Beja, you can turn your camera back off. To understand why Miss Donaldson is spreading these rumors, we have to travel together back in time, back to just 2 weeks after her father's disappearance. It's the broiling hot August of 2012, and Cam Donaldson's blood has just run cold. In front of her, she's holding her father's will. Her throat is stopped up with emotion, and her eyes are filled with angry tears. She's reading that will again and again and again, looking for some kind of mistake. But there is no mistake. Her father's intent is clear as day. The words are black and white. Karen Beja will inherit everything from her father's estate. And in that moment, Cam is hurt. She thinks to herself, Dad, how could you? I answered your phones for 20 years. I ordered your supplies for 20 years. I did everything that you asked me to do. I loved you. How could you choose her again? And suddenly, Miss Donaldson is traveling back in time, remembering the day that her father left her mother for Karen. The day that her father brought Karen to the zoo, practically a stranger, and made Miss Beja an owner. And suddenly it just doesn't seem fair. And all Miss Donaldson wants to do is change what's on that will, but she can't. For 4.5 years, she's not concerned about this will. But then 1 month before her father's estate can close, just 1 month before her father's wishes can be fulfilled, Miss Donaldson has an idea. She calls up a private investigator. She spins a sensational story. She starts spreading rumors, and she starts working on her revenge. Members of the jury, that's why we're here today. Because the rumors and the reality just don't match up. And because Miss Beja does not deserve Miss Donaldson's revenge. At the beginning of these proceedings, you learned that the plaintiff has the burden in today's case. They are the only ones with a burden, and that burden is heavy. Because today, they need to show you that it's more likely than not that Miss Beja transformed in the course of 2 days from a loving, dedicated, hardworking wife of 11 years into a monster. They won't be able to meet that burden today. That burden will remain behind their screens throughout the duration of this trial, because no matter how many stories Cam Donaldson tells you, no matter how hard she huffs and puffs and tries to blow Miss Beja's house down, she will not be able to meet that burden. Today you're going to find that Miss Beja is wrapped up in Cam Donaldson's rumors. You can think of each rumor as a thread. Today you're going to find that the reality will allow you to cut through each one of those threads. During today's case, there are 3 threads you need to be thinking about, and that is the will, the rumors, and the alibi. I'm going to address all 3 with you now. Let's begin with the will. Plaintiff's counsel told you that you will hear from Cam Donaldson today. As Cam is speaking, listen for when she found out about this will And listen for how long she waited to investigate. You're also going to hear from their investigator today. And as she talks about her investigation, listen for the holes in her story. Listen for the leads that she didn't follow, the bias she did not consider, the simple searches that she didn't bother to make. Then you're going to hear from our expert, Chris Renner. You're going to learn that Chris Renner is an insurance claims investigator and that he wasn't hired by Ms. Beja to give his opinion. That he was working for his CEO and his CEO was caught up in the rumor mill. And the CEO didn't necessarily want to pay Ms. Beja, but you're going to find something out. That Chris Renner followed the science and the signs and found that there was no evidence linking Ms. Beja to her husband's disappearance. And last, but certainly not least, you're going to hear from Ms. Beja about that will. And you're going to hear that she saw her husband signed. But more importantly, if that doesn't convince you, you're going to hear that this wasn't the first time Lou was generous with her. You're going to hear that she is the sole beneficiary of his $5 million life insurance policy. And what you won't hear is any mention of foul play regarding that life insurance policy. That is the reality surrounding the will. So let's talk about the rumors. Cam Donaldson is going to say a lot of things today. As she speaks, listen to what she says, and then listen for the holes in her story, the characters she can't describe, the things she doesn't know about her father's estate, and most importantly, what her father never gave her. That is the reality surrounding those rumors. So let's talk about the alibi. Today, you're going to hear that Miss Beja, on the night of her husband's disappearance, was exactly where she needed to be, doing her job and taking care of some newborn cubs at the zoo. And you're going to hear that she dedicated her life to these animals, that she was passionate about wild wildlife. You're also going to hear from her brother, who's going to confirm that story. And you're going to learn that her brother is an experienced police officer with more than 15 years of flawless service, with a wife and kids that he loves. Members of the jury, that is the truth within the alibi. The will, the rumors, and the alibi, these are three threads that you can cut through just to set Miss Beja free from Cam Donaldson's rumors. Because the reality and the rumors don't mesh. And Miss Beja does not deserve Cam Donaldson's revenge. Thank you.
Thank you, counsel. For our witnesses, I will ask that the cameras be on for both examining and cross-examining counsel and the witness. Ms. Posey, I see that you're up, so I'm assuming you are calling the first witness or introducing your first proof. Is that correct?
Yes, Your Honor.
Okay. Ms. Posey, I'm going to say this again. I'm not sure what's going on. Your mic is a little low.
Okay.
For you, I've boosted my speaker,
Okay.
and we'll all live with that. I'm just asking you, it's not a criticism, it's not a scoring point. Just want you to know that.
Okay. No
Are
worries.
you prepared to call your first witness?
I am, Your Honor. And if at any point you're having too much difficulty hearing me, I'll switch microphones. Just feel free to interrupt.
And we shall do that. So I need defense counsel's camera opened as well, whoever is defending on this witness. And then we will need the witness. So who are you calling, please?
Your Honor, the plaintiff calls Cam Donaldson to the stand.
Okay, fine. All right. Counsel, you may proceed with the direct examination.
Good evening. Can you please introduce yourself to the jury?
Yes, my name is Cam Donaldson.
And Ms. Donaldson, what is your relationship, if any, to Lou Donaldson?
I'm his only child.
And as his only child, would you say that you were close to your father?
Yes, we were very close.
If I showed you a photo of your father today, would you recognize it?
Yes, I would.
Referring the witness as well as opposing counsel to what was previously marked as Exhibit 3. Ms. Donaldson, if you'll just let me know when you have that in front of you.
Yes, I have it in front of me.
Okay, do you recognize this?
Yes, I do.
How do you recognize it?
It's a photo of my father and I from when I was a young girl.
And is it a fair and accurate copy of that photo?
Yes, it is.
At this time, the plaintiff moves what was previously marked as Exhibit 3 into evidence as Plaintiff's 1.
Any objection?
Yes, Your Honor, 401. I'm sorry, Your Honor, sidebar and 401.
Sidebar, the objection's overruled. It's admitted.
I can't hear you.
We've lost you, Ms. Posey. I'm so sorry.
We will make it work. Can you hear me now? We'll make it work with that one. So at this time, permission to publish to the jury via shared screen?
Sure, briefly.
Ms. Donaldson, if you'll just let me know when you see that view.
Yes, I do.
Now, I know this photo was taken a while ago, but does it accurately represent your relationship with your father before he died?
Yes, it does. We were really close when I was little, but then Dad brought me into the business and we spent almost every day together before he died. He even joked that I knew more about this than he did.
Thank you, Ms. Donaldson. Now, you mentioned your father's business. What exactly did he do for a living?
He owned Wild Wildlife Big Cat Sanctuary. He had such a big heart and he loved the animals. He saved lions, tigers, leopards, you name it.
Was this always your father's career?
No, he started off in sales. He was completely self-made and didn't have much of a formal education, but he worked really hard and finally got to do what he always wanted to, which was start up the sanctuary and save the cats.
Now, in helping your father run his business, are you aware of what his business was valued at before he died?
Yes, I believe it reached around 5 million.
And are you still employed at the cat sanctuary?
No, unfortunately, Karen Baja fired me after my father disappeared.
Can you tell us who Karen Baja is?
Yes, she was my dad's wife when he disappeared.
And how long had your father been married to her?
I believe about 10 or 11 years.
Did you and the defendant get along?
No, I believe she's the reason my dad is dead, but we didn't get along before that anyways.
Why do you say that?
Well, my dad left my mom for Karen, so I admit that got me off on the wrong foot, but we were certainly civil to each other at work. But I never came around to really liking her the whole time that they were married.
Being with the defendant, you said that you worked with her? She worked with you and your father?
Yes, that is correct.
Now, did you, I'm sorry, let me backtrack for just a second. You did just say that your father left your mother whenever he met Ms. Baja.
Yes, that is correct.
Can you tell us how, if at all, did that affect your relationship with your father?
Well, it didn't affect my relationship with my father or my mother. I saw my parents as two adults, and so it didn't really affect the relationship that I had with them. I was an adult by the time that they got divorced.
Now, at work with both your father and the defendant, were you able to observe anything about the relationship?
Yes, I was.
Can you tell us what those observations were?
At first, obviously, my dad was a total smitten kitten with her, but as the decade went on, they began to drift apart. Before he died, things definitely were not good between them.
Objection, Your Honor. Sidebar, speculation.
Your Honor, you're muted.
I will allow it, subject to, I'm assuming they can lay a foundation. If not, renew the motion.
Yes, Your Honor.
I'll repeat my question, Ms. Donaldson. What, if anything, did you observe about your father's relationship with the defendant?
At first, he was obviously a total smitten kitten with her, but as the decade wore on, they began to drift apart. And then before he died, things definitely were not good between them.
Would you say that you saw your father and Ms. Baja in the same room every day at work?
Yes, I saw them almost every day at work together.
And what is it that makes you say that their relationship wasn't so great?
They fought a lot.
Were you personally able to witness any of these arguments?
Yes, I was.
Do any of these arguments specifically stand out in your mind?
Yeah, a couple weeks before he disappeared, I heard them having a pretty bad fight at the office.
Can you tell us what that fight was about?
My dad wanted a divorce.
And do you remember, did you observe the defendant's reaction to this?
I'm sorry. I don't know if I was heard. Objection, sidebar, hearsay.
Did not hear that, but I've got that. We are at sidebar. Go ahead.
My objection was hearsay, Your Honor, as to Lou Donaldson's statement.
What's your response briefly, Ms. Posey?
Your Honor, this goes to both Donaldson's state of mind as the victim and the defendant's, the effect on the defendant. She knew that her husband wanted a divorce and therefore her motive to kill him.
The objection is overruled.
Now I'll repeat my question, Ms. Donaldson. What was that fight about?
My dad wanted a divorce.
And were you able to see the defendant's reaction to that?
Yes, I was.
Can you tell us how she reacted?
Oh, she was furious.
Objection, speculation.
Overruled.
Were you able to observe your father during this argument?
Yes, and when I tell you I have never seen my dad like that, he was so upset, red-faced, yelling. I mean, that's the most upset that I've ever seen him.
Now, Ms. Donaldson, did you stick around for the remainder of that argument?
Yes, I did. I was there when my dad stormed out of the office.
What happened when your dad stormed out of the office?
He was just so worked up. He stormed out and realized I had been there the whole time and heard the whole thing, and he shouted at me, "If anything ever happens to me, have the police look into Karen because she will be the one responsible for my death."
Thank you, Ms. Donaldson. So at this time, I'd like to get into your father's disappearance just a little bit. Can you tell us what was the last time you saw your father alive?
That would have been Friday, August 17th, 2012.
And can you tell us about that interaction?
He was leaving work in the evening and he yelled goodbye at me. He said he'd see me Monday unless I wanted to come over for supper on Sunday.
Objection, sidebar, hearsay.
Response, Ms. Posey?
Again, this just goes to the state of mind of the victim. Today, the defense is alleging that he ran off to Costa Rica and planned to not return, but Mr. Donaldson clearly planned to see his daughter just maybe 48 hours later.
Well, that's not the effect on the listener. Let me hear from Ms. Arroyo. Ms. Arroyo, is this state of mind planned?
No, Your Honor. This is being offered for the truth of the matter asserted. Cam Donaldson will use this statement ultimately in her testimony to say why it was so much more likely that element 2 is met in this case. His father broke away from those intentions. So it is being offered for its truth, even though it does appear to mimic that exception.
I don't want to be rude. I don't understand. It's either in the exception or it's not.
Not in that exception.
Why?
It's being offered for the truth of the matter because of the way that plaintiff's counsel will use this case. They're going to use this as a statement for its truth to say that Lou Donaldson, in fact, intended to go and do these things, and it will go to element 2.
And isn't that what state of mind specifically allows? It includes a statement of plan or intent.
Your Honor, I only rest on my previous arguments.
Very good. The objection is heard, and I appreciate the argument. The objection is overruled. Continue, please, Ms. Posey.
So, Ms. Donaldson, after your father made plans with you for Sunday, did you have any knowledge of where he might have gone after he left the office?
No, but his van was found a few days later at an airstrip with his keys and glasses inside.
You said at an airstrip. Was your father a pilot?
Yes, he was.
Did he ever fly out of this particular airstrip?
No, that airstrip was 40 miles outside of town. I never knew my dad to keep any of his planes there.
And you noticed that there were keys and glasses that were left behind. Knowing your father so well, did that indicate anything to you?
Well, my dad is blind as a bat. He can't fly without his glasses.
Had you ever been flying with your father?
Oh, tons of times. He had been flying since I was a little girl.
And to clarify, when you went flying with your father each time, did you see him wearing those specific glasses?
Yes, every time. Dad was pretty stuck in his ways. He had had those glasses since I was in high school and only used them.
Now, Ms. Donaldson, did you have any idea and were you aware of any plans your father had to leave the country?
No, none.
Did he typically tell you when he was going to leave the country?
Yes, he always told at least me or my mom so that someone would know where he was going. And even if by chance he didn't mention it for some reason, which he wouldn't have, I would have known that he was gone because I worked with him Monday through Friday. So it would have been pretty apparent if he went somewhere.
Now, were you aware of your father having a mistress in Costa Rica?
No, I wasn't. I didn't like Karen anyway, so there wouldn't have been any reason for him to hide it from me.
Now, I'd like to talk about Karen, or excuse me, the defendant for just a moment. I'm sorry, was there an objection?
Yes, Your Honor. Objection, sidebar speculation as to the reasoning of her father hiding.
That objection is sustained. That answer is stricken.
Yes, Your Honor. Now, I'd like to talk about the defendant for just a moment. When your father first took the defendant as a mistress, did he leave his home and move in with her?
No, she moved in with him.
Did he leave his business for her?
No, he just brought her into the business.
Did he leave you, Miss Donaldson?
No, nothing has changed between my father and I when he married Karen.
Did you ever feel that he chose you, or excuse me, chose her over you?
No, never.
Now, earlier you mentioned that your father had invited you to dinner on Sunday. When was that supposed to occur?
That would have been Sunday, August 19th, 2012.
And did that dinner ever occur?
No, and that's when I started becoming really worried.
Did anything else occur over that weekend that caused you to become worried?
Yeah, it was really unusual for me to go that long without at least hearing from my dad. And on top of that, something really weird had happened at the office that Sunday morning.
Can you tell us what you mean by weird, Miss Donaldson?
Well, at around 6 in the morning, the alarm went off. And when I arrived, the gate or the lock on the front gate had been cut and the back entrance to the office had been damaged.
Did you take photos of the scene that you just described?
Yes, I did.
And would you recognize those photos if I showed them to you today?
Yes, I would.
I'm referring the witness and opposing counsel to what was previously marked as exhibits 4 and 5. Miss Donaldson, if you'll just let me know when you have those in front of you.
Yes, I have them in front of me.
Okay, do you recognize these?
Yes, I do.
How do you recognize them?
It is the photos of the cut lock and the damaged back entrance.
Are they a fair and accurate representation of the photos that you took that day?
Yes, they are.
Okay, at this time, the plaintiff moves to enter what was previously marked as exhibits 4 and 5 into evidence as plaintiffs 2 and 3.
Any objection?
No objection, Your Honor.
Thank you. They are admitted.
Thank you. May I publish via shared screen?
Yes.
Okay, Ms. Donaldson, if you'll just let me know when you see those photos in front of you.
Yes, I see them.
Okay. Now, Ms. Donaldson, why was this scene that you found significant to you?
Well, I know that my dad stored important things in the main desk, which was my desk.
What types of things did he store?
He kept his will in a lockbox, which was in the bottom drawer of my desk. That's where he had always kept it.
And when you saw this scene, did you actually go into the office?
I was about to, but I was stopped short.
What stopped you?
I saw Karen coming out of the office.
Was it normal for the defendant to be in the office on a Sunday morning that early?
Maybe if my dad was with her, but this time she had clearly broken in.
Why do you say that?
Well, in addition to the cut lock on the gate, she had a man with her who was carrying lock cutters.
And was anything missing from the office?
Yes, Karen was carrying the lockbox with my dad's original will.
Hey, Ms. Donaldson, I'd like to talk about that lockbox then. The original will that was in that lockbox, had you ever seen it?
Yes, I had.
And this will, was it the one that was given to the insurance company or the one that was executed?
No, it wasn't.
Can you tell us then what was in that new will that was executed?
Objection, Your Honor. As to any statements from the will, I object to hearsay, hearsay within hearsay, and 1002 original document concerns.
I think though she asked for what's in the new will.
My mistake. I thought she was acting as the will.
At first I wondered that also, but she asked about the will that was submitted to the insurance company, which, assuming there are two wills, would be will number 2.
Yes, Your Honor.
Are you withdrawing your objection in that light?
Withdrawn, Your Honor.
Thank you. What was in will number 2?
Go ahead, Donaldson, you can answer the question.
It gave everything Dad had to Karen, nothing to his daughter.
Your Honor, as to the second will, as to hearsay and hearsay within hearsay. And 1002, again, they have not yet submitted this document before the court, and the statements contained therein as to her father's intent are hearsay.
Ms. Posey, briefly.
Yes, Your Honor, this witness isn't getting into the details of the will as the experts will. She is just saying her personal knowledge of what happened that day that will was executed and she received nothing.
If I may, is that second will going to be produced later in the case?
It will, Your Honor.
Then I will overrule the objection under Rule 104B, conditional relevance, subject to be being revisited, Ms. Arroyo, if for any reason they don't introduce it.
Yes, Your Honor.
You may proceed.
Ms. Donaldson, I'll ask again, can you tell us what was in that new will when it was executed?
Yes, it gave everything Dad had to Karen, nothing to his daughter who had played a vital role in his business, and nothing for the animals that were so dear to him. And some weird...
Your Honor, speculation as to her father's opinions of the animals. She can only state to what she observed about her father and cannot actually peer into his mind and say what was important to him.
Respectfully overruled. And the question was answered. Go ahead.
Now, Ms. Donaldson, everything that was given to the defendant in this new will, was that the original plan from the lockbox?
No, the original will would have divided my dad's assets equally between me, my mom, the defendant, and the sanctuary.
Your Honor.
That language about just...
Yes.
Sidebar and renew my first objection as to the contents of that first will, which were hearsay, hearsay within hearsay, and 1002.
So where is the first will, Ms. Posey?
Your Honor, so this original will was something that Mr. Donaldson kept in his daughter's desk, which was the main desk at the office. Unfortunately, we aren't able to produce any copies of that because, if I may be heard at sidebar, just to clarify.
I thought we were at sidebar.
Just to make sure, because what I'm about to say, because as this witness will testify, Ms. Baja destroyed that copy of the will so that no one would ever see it and then forged this will. And I'm not...
Response.
Your Honor, as to this 1002 objection, they haven't shown any testimony to show that Ms. Baja destroyed this will, and the one-sided account from this witness who has a bias against Ms. Baja should not suffice to establish that Ms. Baja has destroyed this will. And I still request that opposing counsel address both my hearsay and hearsay within hearsay concerns.
I'll decide what she has to address, but you've made the objections and I've got you there. I simply asked, but you're right, that's a separate objection. Under Rule 1004 and 1008, whether there was a first will is a question of fact for the jury as long as there is some basis. So the objection is overruled. Go ahead. We heard, though, the answer, I believe, and on the hearsay ground, respectfully, that objection is overruled as well. So we heard there was 25, 25, 25, 25.
Yes, Your Honor.
Please move along.
Now, Ms. Donaldson, since that wasn't the same distribution that was in the original will, you also mentioned something about disappearing. Was that in the original will?
Of course not. Who puts "should I disappear" in their will?
Did you ever consider the possibility that your father just cut you out of his will?
No.
Objection is sustained to that.
I'm sorry, Your Honor, you cut out. What was that?
I said the objection which I am making is sustained to that question. Move along, please.
Yes, Your Honor. Now, I want to talk about what happened after that day. You said that happened on Sunday. The following Monday, did you go into work with the defendant?
Yes, I did, but she fired me as soon as I walked in.
Was it odd to you that the defendant fired you?
Yes, she didn't have the authority to do that. She didn't own the sanctuary. My dad owned the sanctuary, and Karen was the only person who was reporting him missing at this point.
Now, Ms. Donaldson, since you said she didn't have the authority to fire you, why did you then leave?
I didn't want the drama with her. For all I knew, my dad could come back into the office anytime and he would clear everything up.
Now, when you were present at your father's will execution, can you tell us exactly what happened?
At my dad's will execution, she got the rest of everything he had, his entire estate worth $5 million plus another $5 million payout from the insurance based on this new will. She had my dad declared legally dead 5 days or I apologize, I misspoke. 5 years to the day that he was missing. Legally, she had to wait that long.
Ms. Donaldson, what is it that you're here for today?
I just want what rightfully belongs to my family, what dad worked hard for, and for it not to go to the person who killed him.
Ms. Donaldson, can you tell this jury, how has your father's death affected you?
It's turned my whole world upside down. It's been 8 years, but it hasn't gotten any easier. I think about him every single day. I got to see dad every day and work with him at the sanctuary, but now I don't have my dad or a job. I can't even go to the sanctuary to feel connected to him or to carry out his legacy. It's all just been really devastating for me and for my family.
I apologize. Thank you so much, Ms. Donaldson. No further questions at this time, Your Honor.
Thank you. Ms. Arroyo, are you ready to cross-examine?
Yes, Your Honor.
Please do.
Ms. Donaldson, I'd like to address a few of the things that you just said on direct examination. You said that you flew all the time with your father, correct?
Yes, he'd been flying since I was a little girl.
And you said that Miss Beja was your father's mistress, correct?
Yes, my father met Miss Baja after or while he was still married to my mother. I believe he picked her up while she was hitchhiking.
You also said that Miss Beja fired you just as soon as you walked into the office.
Yes.
That following Monday.
I apologize for cutting you off. Yes, she fired me that Monday morning.
As to these three statements, are you aware that when you made the deposition in this case that you were supposed to include all information pertinent to today's matter?
Yes, and I did involve any information that was pertinent to this matter.
Are you aware that you are under oath and were supposed to tell the truth at all times?
Yes, and I did tell the truth at all times.
Ms. Donaldson, am I to assume that we all have copies of your deposition available to us, or should I publish that to you?
I do not have it readily on hand, but I do have a copy of it if you allow me to go get it. Or if it is quicker just to publish it, then you may as well.
I will publish, I suppose, each page as we go through this in just a moment.
Your Honor, to clarify, this is outside the presence of the jury because a document like this is never to be seen by the jury.
I think we're at sidebar now. Why is a document like this never to be seen by the jury? I've never heard that objection before.
Your Honor, this is her prior statement. They are inadmissible hearsay in trial. She's publishing her deposition before this trial.
I'm assuming it's to impeach her.
It is, but she's having to show her my witness doesn't have it in front of her. So in order to show it to her, she's publishing it, which if she does complete the impeachment, she may publish it afterwards. But at this point,
I don't know of a rule that says that respectfully. There is no rule that says you can only show it after you have impeached. That objection is overruled. Ms. Arroyo, is this an impeachment by omission?
Yes, Your Honor.
Okay, go ahead.
I'm going to do my best to share each part of this screen with you. I think I should be in control of it. But please show me where on the first page of your deposition you mentioned that you flew all the time with your father.
I honestly didn't believe that it was pertinent to the investigation that we were at. I'm my dad's daughter. That's just information about our relationship. I apologize for not including it, but again, I did not believe that it was pertinent to our current
You
situation.
are aware that pursuant to the local rules, you are limited by your deposition as to what you testify, correct?
Objection, Your Honor. On this point, and specifically, this is an improper impeachment. She's admitting right now that she did not say this because it was just typical information that anyone would assume about her because of her father.
That objection is overruled.
My impeachment continues. Now, thank you, Your Honor. I was just in the flow. I'd like to now put you back to your deposition and ask you where you mentioned before that Karen was your father's mistress.
I do not believe that is in my deposition, but I believe Ms. Baja mentions in her deposition that she met my father while they were hitchhiking and that he was still married at the time.
You realize that pursuant to the local rules, you are limited in your testimony to what is in your deposition.
Once again, Your Honor, I'm going to object that this is a reasonable inference. She has personal knowledge about her father. She was never asked about her father's mistress, just her relationship with her.
Your Honor, if I may.
The objection is overruled. Continue with the cross. Can we agree that the word mistress was not mentioned by Ms. Donaldson? Yes, by Ms. Donaldson.
Yes, Your Honor.
Fine. Ask your next question, Ms. Arroyo.
No further questions, Your Honor.
No further questions on the deposition or no further questions at all?
On the deposition.
Got it. Then let's take that down and end the share screen conflict. Please proceed.
Now that we've sorted that out, I'd like to kind of go through your relationship with your father. You worked for your father for 20 years, right?
Yes, that's correct.
Your father was a hardworking man.
Yes, he was. He was almost completely self-made. He worked really hard to do what he loved to do.
You were passionate about wildlife almost just as much as he was.
Yes, I love those cats. I worked with my dad, like you said, for 20 years.
Your father founded the Wildlife Emporium by himself.
Yes, he was so passionate about these animals. And like I said, he worked really hard. He was completely self-made.
You were not a founder, correct?
No, I would have been too young at the time, but he brought me on as his assistant to help him.
You never became an owner either, correct?
No, I didn't, but I was more than happy in my role. I played a vital role to the business. I did pretty much everything. I ran the books. I did it all. I was happy to work with my father. We had such a great relationship. We were really close.
Let's talk just a little bit about that vital role that you played at this business. You ordered supplies?
Yes, I did a lot of stuff. I was, like I said, a vital role. I even ran the books.
You did anything and everything that was asked of you?
Yes.
You said during your direct examination today that you saw a couple of arguments between your father and Miss Beja.
Yes, I saw and I heard them.
At that first argument with your father and Miss Beja, the only people present were you, your father, and Miss Beja, correct?
I'm sorry, are you referring to the argument that was 2 weeks before he disappeared? I'm just confused. I'm trying to clarify. I apologize.
At either of these arguments, the only people present that you mentioned on the stand today were you, your father, and Miss Beja.
I can't be 100% certain, but I know that I was there as well as my father and Miss Baja. I don't know if anyone else was there.
Well, today you didn't testify that anybody else was present, correct?
I did not testify today because I do not have personal knowledge of anyone else being there.
All right, then let's talk about the events surrounding your father's disappearance. You mentioned an event that happened on Sunday, August 19th, 2012.
The Karen breaking into the sanctuary, is that what you're referring to?
Yes, that day you said that Miss Beja robbed your business.
Yes, she did rob Wild Wildlife Sanctuary. She didn't rob of anything financial, but she did take the lockbox that was stored in my desk.
We're going to get into that lockbox in just a minute, but I'd like to focus on what you saw Miss Beja do while she was there. The reality is you saw Miss Beja speak to the police.
Yes, I saw Ms. Baja walk out of the office with a man carrying lock cutters and a lockbox.
That wasn't my question. You saw her speak to the police that day, correct?
The police drove in after me, so yes, she eventually did speak to the police, yes.
Saw her tell the police that she was the owner of Wild Wildlife, correct?
Yes, and as I previously stated, she wasn't the owner at the time. My father was the owner.
The reality is, Miss Donaldson, you never told the police on site that she was not the owner.
That's correct. I didn't want any drama with her. Like I've previously stated, I thought my dad would be back at any point.
And with regard to the lockbox you said that she stole today, you didn't tell the police on site that she stole that lockbox.
No, because she was carrying it, so I didn't feel the need to. It was pretty obvious that she was carrying it.
So that was a no, you didn't report her for stealing the lockbox?
The police followed me in. I didn't call them.
Miss Donaldson, respectfully, I'm going to ask that you try to answer yes or no questions, yes or no questions.
Okay, Your Honor.
With yes or no answers, forgive me. Did you report it to the police?
No, I did not.
On the stand today, Miss Donaldson, you said that you believe that Miss Beja burned your father's original will, correct?
I didn't say that on the stand today. No.
Or?
I said that in my deposition, yes, but I didn't say it on the stand.
The reality is, Miss Donaldson, in your own words, you don't know what happened to that will.
No, Karen made sure of that.
You said, Miss Donaldson, that Miss Beja showed up 2 weeks later after that break-in.
Yes.
She showed up with a will, correct?
Yes, with that new will.
A will that you described as laughable.
Yes, it was.
You hired Taylor Pye to investigate that will.
Yes, I did.
You didn't hire him to investigate that will in 2012.
No, I did not. I did not hire her at that time.
You didn't hire her in 2013 either.
No, I didn't hire her at that time either.
You waited until 4.5 years later in 2017.
Yes, I waited that long because I was holding out hope that my dad would return. I knew that it was coming up on the 5 years to have him legally declared dead, and I was losing hope, but I had been holding out hope that he would still come back and be alive.
Right. Turning your attention back to the events surrounding this break-in, you mentioned that Ms. Beja was with a man.
Yes, he was holding lock cutters.
You described this man as scruffy.
I believe so, yes.
You didn't describe today his eye color.
No.
His skin color.
No.
What he was wearing.
No.
The reality is you only described this man as being scruffy.
Yes.
Objection, Your Honor, relevance.
Your Honor.
Overruled. Please proceed.
Ms. Donaldson, pointing you to the issue in today's case, you said that Ms. Beja killed Lou Donaldson.
Yes, because I believe she did.
You didn't see Mr. Donaldson on the day that he disappeared, August 18th, correct?
I saw him that Friday, August 17th.
You never saw his body, right?
No, unfortunately, no body was recovered.
You never saw any DNA evidence?
No, I trusted the police to do their investigation, but I wasn't a part of that investigation.
And you also never saw a murder weapon?
No, again, I wasn't a part of the police investigation, so I don't know.
Earlier, we agreed that you and your father were very close.
Yes, we were.
You're aware that he bought and sold planes all of the time.
Yes.
In your own words, he never properly registered those planes.
Yes.
In your own words, you don't know how many planes he owned.
That is correct.
You also know that he flew on more than one occasion without logging a flight plan with any of the local airports or airstrips.
Yes, rarely that would happen.
And because of your close relationship with your father, you knew that his license was suspended at the time of his disappearance.
Yes, I did know his license was suspended at the time of his disappearance.
No further questions at this time, Your Honor.
Thank you. Brief redirect if you need.
No redirect, Your Honor. May this witness be excused?
Witness may be excused. Does the plaintiff have any other evidence?
Yes, Your Honor. At this time, we would call the unavailable witness, Bob Exotic.
How do you proceed? Intend to proceed?
And my co-counsel actually has that video if she may publish to the jury.
Okay.
Your Honor, it was our understanding that this video would not be shown today per our ruling at the beginning of today's trial. They were talking about the statements that could be read onto the record, but not this particular video. And if I remember correctly, Your Honor specifically stated, and opposing counsel specifically stated, we would not be using the video in today's case.
So let's go to sidebar very briefly. I apologize. I don't recall discussing video or non-video. I thought we simply discussed whether this was or was not a declaration against interest, and within that a statement of a party opponent, and I approved the admissibility of the words. Are you raising a new objection now? Mr. Hobbs, I'm an old man, sometimes my memory goes. Ms. Posey, do you remember if we discussed video versus non-video? I don't.
No, Your Honor, and this is the original form of this. There is a transcript, but this was what we were intending when we spoke about MILs. We did not specifically say one or the other, but it was our intention that this.
Right. We talked about the fact that this was said on a music video.
Yes, Your Honor.
Right. I don't, Mr. Hobbs, what's the objection?
Yes, Your Honor, I would object to hearsay again and to 403 and this being in the format of the video. I believe it would be more prejudicial to the jury to see this video instead of the read testimony of Joey or Bob Exotic in this case.
Well, the hearsay's been ruled on, counsel.
Then I would simply make the 403 substantially more prejudicial than probative objection at this time.
You're not putting any meat on those bones, so respectfully, I'm denying that motion.
Yes, Your Honor.
Play the video, and let's move it along.
Oh, counsel, there is no sound playing.
Please remember that when you use share screen, you have to click the box that says allow the audio. You'll have to unshare, try it again, and there's a box that you hit that when you go to share screen, there's a box in the lower left-hand side that says share computer sound. Try it again, please.
Hey there, cat sister, where'd you put your mister? Feed him to the lion's den. Hey there, cat sister, where'd you put your mister? Feed him to the lion's den, den, den. Hey there, I'm Exotic Bob. You probably recognize me as the owner of the world-famous leopard camp, I See Spots. I want to thank you for your patronage over all these years. I'm currently a guest of the Federal Maximum Security Hotel System. Compliments of one Karen Baja, and that's who I'm here to talk to you about today. You see, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. We was illegally importing leopards and lions. Leopards was for her, leopards was for me, lions was for her. Now, we'd never worked together before, and we'd never worked together since. But due to the severe illegality of the deal, we thought it best to be worked together, so we did. And at the end of that meeting, Karen Baja walked out of my office. She stopped suddenly, turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye and she said, "Exotic Bob," that's me, Exotic Bob. She said, "Exotic Bob, I swear if you double-cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica." She goes, "Your last supper will be you. I'll feed you to my kiddies just like I did him." And then she turned around and she walked out of my office. That's all I've got to say about that. Hey there, evil woman, where you think you're going? We all know where you've been. Hey there, evil woman, where you think you're going? We all know where you've been.
Please end screen share. Thank you. You're muted, Ms. Maxwell. Do you have another witness?
Yes, Your Honor. The plaintiff calls Taylor Pride to the stand.
Thank you. Ms. Pride, good evening. You've been sworn. Keep your voice loud and clear. Ms. Maxwell, proceed.
Would you please introduce yourself to the jury?
Yes, my name is Taylor Pride.
What do you do for a living, Ms. Pride?
I am a private investigator and forensic document examiner.
Now, I'd like to talk to you a little bit about your background before we talk about why we're here today. Let's start with your career as an investigator. How did that begin?
Yeah, I started off as a patrol officer with the Pioneer Police Department, and that was back in 1998. About 2 years later, I was promoted to detective, and then I continued working there for 16 years before going off into my own private firm.
How long have you had that private firm opened?
I've had that open since 2016.
Now, over the course of your career, what types of crimes have you investigated?
Oh, I've investigated every kind of crime, everything from economic crimes all the way up to murder.
Now, let's talk about your qualifications as a forensic document examiner. Could you tell us exactly what a forensic document examiner does?
Of course. My job is to analyze handwriting and signatures to make sure they're authentic and to see essentially who wrote those things.
How long have you been doing this type of work?
Well, I was assigned to the economic crime unit while I was at the Pioneer Police Department, and I worked in that unit from 2002 to 2008, and a lot of that time was spent investigating forgeries.
Now, since leaving that unit, have you continued to work in this field?
Yes, I still do this sort of investigating in my private firm as well.
Do you have any training in the area of forensic document examination?
Yes, I do. Back in 2002, when I started in that economic unit, I attended an extensive 2-week seminar, and there I learned how to analyze and compare the handwriting.
Now, did you receive any certifications in this area?
Yes, after the seminar, I went through the certification process with the American Board of Forensic Document Examiners.
Could you tell us a little bit more about that certification process?
Yeah, so it's broken up into 4 parts. The first part is I have to show them my credentials as well as some references. And then you have to complete a multiple choice exam. And then there's a practical exam, and then there's an oral exam.
Now, after receiving this accreditation, did you do any further training in the area?
Yeah, well, every year I attend an 8-hour course, and this is just annual to stay up to date. I also keep up with all the current literature and get recertified every 4 years.
So, did you use the principles and methods that you learned in the training that you've just described in your investigation in today's case?
Yes, I did.
Have you ever testified before in court?
Yes, I've testified about 15 times since I was certified back in 2002, and that's on civil cases and criminal, as well as both sides of those cases.
The plaintiff moves to tender Taylor Pride as an expert in forensic document examination and handwriting analysis.
Your Honor, I believe you're muted again.
Thank you. It takes an old man a minute. Mr. Hobbs, do you have any questions on the qualifications for the expertise as proffered, which I heard was handwriting and forensic document examination?
Yes, Your Honor. I would object to a lack of foundation.
No, I just asked, do you have any questions on voir dire?
No, Your Honor, no questions.
Great. Do you have an objection or a motion?
Yes, Your Honor. I would object as to this witness being qualified as an expert, as the predicate under 702 has not yet been fully satisfied. And in order for that expert to be qualified in court today, plaintiff's counsel must lay that foundation before that expert can come before the court today as qualified as an expert.
So you've restated legal principles, but you haven't told me in plain words, what do you think is missing?
Yes, Your Honor. We've yet to hear what sorts of information was relied upon in today's case. We've yet.
No, counsel, that will go to the quality of her opinion. This is only her qualifications. Does she have expertise?
Yes, Your Honor. She does have expertise.
Right. So solely on the issue of, is she an expert such that if there is enough data and proper methodology, she can give an opinion. Do you have an objection on her being admitted as an expert on forensic document and handwriting analysis?
Not at this time, Your Honor, to that specific objection.
Got it. Okay. If there's an objection to an opinion, I'm with you. I'm only on the qualifications.
Yes, Your Honor.
Thank you, kind sir. You may proceed. I approve the witness to give opinions as an expert, assuming there aren't other objections, on forensic document and handwriting.
Thank you, Your Honor. Investigator Pride, now that we've established your background, let's talk about why we're here today. When did you become aware of Lou Donaldson's disappearance?
Yes, I was hired by Cam Donaldson in 2017 to investigate the disappearance as well as the will.
Let's talk about your investigation of that will first. Would you recognize a copy of that will if I showed it to you today?
Yes, I would.
I'm referring the witness and opposing counsel to what has been previously marked as Exhibit 14. And Investigator Pride, if you'll just let me know when you have that up.
Yes, I have that.
Do you recognize this, Investigator Pride?
I do.
How do you recognize it?
This is the will that I looked at as part of my investigation.
Was it in the same or substantially similar condition as when you last saw it?
Yes, it is.
The plaintiff moves into evidence what has been previously marked as Exhibit 14 into evidence as Exhibit 4, I believe.
Any objection, counsel?
No objection this time, Your Honor.
Great.
All right, may I publish to the jury via share screen?
So let me make clear, unless either of you objects to publication, when you say that you don't object to admission, publication may follow.
Yes, Your Honor.
Thank you.
Now, Investigator Pride, what date was this will signed?
That was June 14th, 2012.
Was there anything about the wording of this last will and testament that stood out to you in your investigation?
Yes, the will specifically states that Mr. Donaldson is leaving everything to Miss Beja if he should die or disappear.
And why was that significant to you?
Well, in my time investigating forgeries, I've looked at a lot of wills over the years, and I've never seen the term "or disappear" included.
Could you tell us a more specific number about how many wills you've investigated during your career?
Hundreds.
Now, did you look into the witnesses of this will?
Yes, there were 2 witnesses that signed the will.
And who were those 2 witnesses?
It was the defendant as well as Samantha Lane.
Now, was there anything significant in your investigation regarding these witnesses?
Yes, well, right off the bat, it's always questionable when the person that is going to benefit from the will is also a witness to the will.
And in this case, who benefited from this will?
Miss Beja, the defendant.
Now, you also, there was another witness as well, Samantha Lane. Did you investigate her?
Yes, I did contact her.
Now, do investigators such as yourself reasonably rely on witness testimony to go to your conclusions about the validity of wills?
Oh, yes, definitely.
And in your investigation of this will, did the information that you received from Miss Lane go to those conclusions?
Yes, it did.
Now, what information did you get from Miss Lane?
Well, when I contacted Miss Lane, she had told me that she did not actually observe Mr. Donaldson sign the will, but that she had only said that she had previously because she was threatened by Miss Beja.
Your Honor, I don't know if my objection was heard, but I objected to hearsay.
Let's go to sidebar. Was this not one of our pretrial motions?
Yes, Your Honor, it was.
What was my ruling?
Your Honor, your ruling was that Samantha Lane is only for investigation quality, pursuant to our own expert witness. There was nothing said in that pretrial motion to allow this expert to testify in any way as to anything that they heard from Samantha Lane.
If I may be heard, Your Honor.
I thought my ruling, if I may, Ms. Maxwell, and help me out here, was her words don't come in for the truth, but to explain the quality or lack of quality of the investigation and the follow-up or non-follow-up, something like that. Isn't that right?
So to clarify, there were two instances of Mrs. Lane's testimony that we discussed in motions in limine. The second goes to the credibility of the defense's witness, and I'm sure we'll get into that again whenever that comes up. But these statements specifically are not being used for the truth of the matter asserted, but simply for the basis of the expert opinion and the direction that Ms. Pride's investigation took once she heard these statements.
Then I'm having trouble distinguishing the two, counsel, because
I'm sorry.
I have no problem if a witness says, I spoke to Miss Lane one time and she said one thing, but then I spoke to her another time, she said another thing.
So, Your Honor, because she signed the will, that is a statement where she's saying that she did see Mr. Donaldson sign the will. And then whenever she spoke to Investigator Pride, whenever she was doing her investigation, she said that that was not the case. And I believe I've laid the foundations for these to come in under 703 as the basis of her opinion to the validity of the will.
I'm going to sustain the objection in part. The expert may testify that there were conflicting statements, but not that I believed one or the other.
Yes, Your Honor.
Your Honor, may I respectfully request that the testimony that the witness just gave, referencing just one of those statements, be struck from the record?
We will strike that and we will return in front of the jury. Please proceed.
Yes, Your Honor.
Investigator Pride, did you contact Miss Lane?
Yes, I did.
And whenever you contacted her, did you receive any information indicating that her testimony by signing the will was not genuine?
Yes, I did.
Now, did you also examine the signatures on this will?
Yes, I did analyze the signatures.
And how did you do that analysis?
Well, the first step is to obtain copies of, well, of course, the will with the signature in question, along with known samples that were signed by Mr. Donaldson.
And what samples did you collect?
Yes, I was able to get his signature from his driver's license, as well as a signature from a restraining order that he filed, and also one from a note he wrote to Cam Donaldson back in 2012.
What did your analysis of these signatures yield?
Yes, well, I observed that both the signatures on the license as well as the restraining order were very similar and clearly written by the same person.
Now, did you compare those signatures to the signature on the will?
Yes, I did.
And what did that comparison yield?
I do not believe that the signatures from the restraining order and the license were the same as the person who signed the will. There were many discrepancies between those signatures.
Could you tell us a little bit more about those discrepancies?
Yes, the person that signed the known samples, they wrote very smoothly and had all of the letters connected. Whereas on the will, the writing was very shaky and the pen was lifted up many more times. Additionally, in the known samples, the O in the end of Donaldson is what we call a lazy letter because you can't really see it. Whereas on the will, the O is very distinctly there. And then again, on the two known samples, the ends of the letters they curve up the same way, and that is distinct from the signature on the will.
And was there anything else specific about Mr. Donaldson's signature on the will that led you to believe that it was not genuine?
Yes, well, along with all the differences, one of the most notable ones was the quivering. This indicates that the signature on the will was done very slowly and perhaps with a nervous, shaky hand. And that indicates that the person was likely looking at another signature and trying to copy it slowly.
Thank you, Investigator Pride. Now, I'd like to talk about the rest of your investigation in this case. Did you look into anything else surrounding the circumstances of Mr. Donaldson's disappearance?
Yes, I looked at many leads and a lot of different possibilities, but in the end, it turned into a homicide investigation.
Now, what evidence led you to believe that this was a homicide?
Well, of
Counsel,
course.
may I see both counsel at sidebar, please?
Yes, Your Honor.
Mr. Hobbs
Yes, Your Honor.
and Ms. Maxwell,
Yes, Your Honor.
you offered this person as an expert in handwriting and document examination.
Yes, Your Honor.
Is this person going to give expert opinion about anything else?
Not expert opinion, no, Your Honor, but she did conduct an investigation into the circumstances surrounding his disappearance.
I'm sorry, I didn't know where we were going, so I wanted to come to sidebar. Let's go back in front of the jury.
Yes, Your Honor.
Yes, Your Honor.
Now, Investigator Pride, during your investigation into the circumstances surrounding Mr. Donaldson's disappearance, what made you believe that it was a homicide?
Yes, well, one factor was the issue with the forgery on the will, as well as I became aware that there were many problems in the relationship between Mr. Donaldson and the defendant.
Now, could you explain what you mean by that?
Yes, I discovered court records which confirmed that Mr. Donaldson had attempted to get a restraining order against the defendant.
Now, in addition to aiding your investigation into the homicide and the disappearance of Lou Donaldson, did these court records aid in your investigation into the validity of the will?
Yes, they're very helpful and important for determining motive, which goes towards the investigation of things such as the will.
Now, do investigators such as yourself reasonably rely on court records such as the one that you reviewed in investigations like this one?
Yes, all the time.
And did you rely on this court record in coming to your conclusions today?
Yes, I did.
So could you tell us, would you court record if I showed it?
I'm going to have to ask you to re-ask that question because your microphone broke up.
Yes, Your Honor. Can you hear me now? Okay. The Investigator Pride, would you recognize that court record if I showed it to you today?
Yes, I would.
All right. I'm referring opposing counsel and the witness to what has been previously marked as Exhibit 16.
Wait, I have it.
Investigator Pride, do you recognize this?
Yes, this is the request for the temporary restraining order that I reviewed in my investigation.
Was it in the same or substantially similar condition to when you last saw it?
Yes, it is.
The plaintiff moves what has been previously marked as Exhibit 16 into evidence as Plaintiff 5.
Any objection?
Yes, Your Honor, to hearsay. May I be heard at sidebar?
Briefly.
Yes, Your Honor, both to hearsay and hearsay within this document. There are statements from Lou Donaldson himself contained in this document, as well as the overall document itself. There's been no predicate laid to allow for this to be brought in under any sort of public record exception. There's no affidavit attached to this that allows that predicate to be laid. So we would object to hearsay and hearsay within hearsay at this time.
What are you offering it for, Ms. Maxwell?
Excuse me, Your Honor, I believe I was a little bit unclear in our last conversation at sidebar, but this document shows the victim's state of mind just 2 days after this will was created. And so the allegations that are contained within it are admissible under 8033 because the idea that his intent would not be to leave his entire estate to Ms. Baja, because of the allegations within them saying that he is seeking a restraining order against her, he is seeking a divorce from her, and other things that are contained within.
Mr. Hobbs, real briefly, if I understand opposing counsel, she's saying that if a person writes, "I'm afraid of Mr. Hobbs," the next day they're not likely to write a will saying, "I'm leaving all my money to Mr. Hobbs."
Yes, Your Honor, that is my understanding as well, although we still have to deal with the entirety of the document itself being hearsay. Much like oil on a pond, you can't reach the hearsay underneath without touching that oil on top first.
I think, though, that's a non-hearsay purpose.
Yes, Your Honor.
So if the limited purpose is to say somebody said these things, and that's inconsistent with writing a will, that objection's overruled.
Yes, Your Honor.
Let's proceed.
So then I can assume that it's been moved into evidence?
Yes, I'm sorry.
Thank you, Your Honor. Now, Investigator Pride, what about this document informed your investigation?
Yes, one of the more significant parts on the document is actually the date. This was filed on June 12th, 2012, which is just 2 days before the will was supposedly signed.
Now, did the grounds that are listed on this order factor into that opinion?
Yes, they go towards the motive and understanding why there may be some inconsistencies between the will and the having a restraining order.
And could you read those grounds for the jury, please?
Yes, it states that Mr. Donaldson believed that Karen Basia, the defendant here, had threatened him. It also states that he was seeking a divorce from Miss Basia and that he does not feel safe around Miss Basia.
Thank you, Investigator Pride. Now, did you find or did you investigate any further into Mr. Donaldson's disappearance?
Yes, there was also a claim from the defendant that Mr. Donaldson had run off to Costa Rica with another woman. So I looked into that claim.
Oh, did you find any evidence here in Statesville that he had fled?
No, I did not. I ended up pulling his financial records and there was no activity after he disappeared. So nothing to suggest that he had gone to Costa Rica.
No, would you recognize a copy of that financial record if I showed it to you today?
Yes, I would.
All right, I'm referring opposing counsel and the witness to what has been previously marked as Exhibit 15. And Investigator Pratt, if you'll just let me know when you have that up.
Yes, I have it.
Do you recognize this?
Yes, this is one of the financial records that I reviewed.
And is it in the same or substantially similar condition as to when you last saw it?
Yes, it is.
The plaintiff moves into evidence what has been previously marked as Exhibit 15 into evidence as Exhibit 6.
Counsel?
No objection at this time, Your Honor.
Thank you. It's admitted and it may be shown.
Now, Investigator Pride, whenever you reviewed this bank statement, how did it inform your investigation?
Yes, well, I noticed that there's nearly $100,000 left in this account. And so if he had fled, as the defendant is alleging, he would have had to do it without taking any money out of this account and instead leaving behind $100,000.
Thank you, Investigator Pride. Now, what were your, were there any of Mr. Donaldson's belongings found here in Statesville, to your knowledge?
Yes, some of his personal items were recovered in a van. It was found at an airstrip about 40 miles away.
What were those items?
It was a pair of his glasses as well as his keys.
Now, what were your final conclusions in this case?
Yes, I concluded that Mr. Donaldson did in fact not flee to Costa Rica and that the will had been forged.
Thank you, Investigator Pride. No further questions at this time.
Mr. Hobbs, do you wish to cross-examine?
Yes, Your Honor. Cross-examination.
Please go right ahead.
Investigator, I want to start with one of your conclusions. It's your belief today that Lou Donaldson did not go to Costa Rica, correct?
That's correct.
And you would agree that being thorough in an investigation is very important.
Of course.
And in fact, you'd also agree with me that in all of your investigations with the police department, you were always sure to be thorough.
Of course.
I want to talk about the investigation you did into the possible claim that Lou may have been in Costa Rica. You're aware that Lou Donaldson owned a variety of planes, correct?
Yes, that's true.
And you've been provided no registry of those planes, have you?
No, I have not.
So you can't tell us today if any of those planes are missing?
No, I cannot.
Something else that we can agree on today is that the distance between Statesville and Costa Rica, that's about 2,200 miles, correct?
Yes, I believe so.
The fact of the matter is that you sent one investigator to Costa Rica 5 years after Lou Donaldson's disappearance, correct?
Yes, I did, to see if there was any trace of him there, and they weren't able to find anything that suggested that Mr. Donaldson was or ever had been there.
And you know that in the planes, the small planes that Mr. Donaldson owned, you would have to make 4
Objection. Calls for improper opinion.
Counsel, this person gave opinions on everything under the sun beyond her expertise. You open this door, he's going through it.
Yes, Your Honor.
Back to my question, investigator. You know that the small planes that Lou Donaldson owned, he would have to make 4 to 5 stops on the way to Costa Rica from Statesville.
Yes, I believe it was more like 3 to 4, but yes.
And the reality is, you didn't send an investigator to any of those other possible cities, did you?
No, I did not.
And the reality is, you didn't search to see if there were any recorded plane crashes in any of those cities near or around the time of his disappearance, did you?
No, I'm not aware of any plane crashes.
You didn't check to see if there were any local news reports about plane crashes?
No.
I want to move on to something else that you mentioned earlier in your testimony today. It's your belief and your statement in court today that this turned into a homicide investigation, correct?
Yes, that is what I believe.
And you were aware that in preparing for today's case, you were required to include everything that you possibly concluded in your report for today's case, correct?
Yes, that's true.
And do you have that report in front of you now?
Yes, I can in just a moment. Yes, I have the report.
Now, if you could please, in that report, and give me a page of that report where you in any way indicate that this was a homicide investigation.
Your Honor, I would object to improper impeachment if I may be heard at sidebar.
Objection is overruled. I want to move this. Is there a mention of the words homicide investigation in the report?
Your Honor, I believe that she concluded that it was a homicide, and I think it's a reasonable inference that it was a homicide.
Is there a word that there was a homicide investigation by the police?
No, she didn't testify that there was one by the police, simply by her.
I'm sorry. The objection is sustained. Move along.
Your Honor, yes, Your Honor. One last thing that I want to talk about today with you is the accounts that you examined. You only presented one of those in court today, right?
Yes, only one was shown today.
In fact, you know that in your report, you're supposed to include attached everything you reviewed for today's case, right?
Yes.
So in reality, you didn't attach all of the other accounts that you supposedly reviewed to your report today.
No, there were no other accounts shown today.
No further questions at this time, Your Honor.
Can we redirect?
No, Your Honor. May this witness be excused?
The witness may be excused. Is there any further evidence from plaintiff?
No, Your Honor. The plaintiff rests.
All right. Friends, we will take a 4, and that is precise, 4-minute recess. Please turn your microphones and cameras off. Do what you need to do. I'm going to meet in a breakout room with the scoring judges for a moment. Thank you.
Hey, Rachel, while you're here, do you mind if you test my mic with me really quick to see if it works now? Okay. Good stuff here. I'm not sure what's happening.
Most of the time those mics work really well, but sometimes they just don't.
And it's like this super fancy like podcast mic. Can you hear me now?
Right now, yeah, it's plugged in. Is it plugged in?
Yeah.
I like you using it because you don't have the background noise, but just maybe speak up like a lot.
Okay. I was like literally trying to hold it here, and I feel like I'm on a podcast or a radio show.
No, you're good though. That's
I
fine.
want to keep it like out of the. Okay, I'll try it. If for any reason I like you stop hearing me, just interrupt me and let me know. And that's our learn to be back.
Do you guys want a time check really quick?
Yes, please.
Okay, plaintiffs, I have you guys at 45 minutes and 32 seconds. And defense, I have you guys at 24 minutes and 50 seconds.
Perfect.
Thank you.
I'm sorry to do this, but was that time elapsed or was that like time remaining? That sounds like a dumb question. I just want to make sure.
Yeah, that's the time that you've used so far.
Okay, perfect.
I believe you have 70 minutes.
Perfect.
I think I'd be remiss not to check. Y'all can hear me, right? Awesome.
I just returned. Is everyone's sound and everything working? May I ask you guys one question? We are at a sidebar right now. What is your understanding on timing and time limits?
As far as we know, we each have 70 minutes and then an additional, I believe we got 4 minutes to make and then 4 minutes to respond to rebuttal, and then time is stopped for objections.
That I know. I have no idea who is monitoring time.
Oh,
Yes. I was keeping track of time.
Thank you.
Yeah.
Can I get a time report, please?
Yeah, the plaintiffs have used up 45 minutes and 32 seconds, and defense has used up 24 minutes and 50 seconds.
Thank you so much. Okay. Thank you. And that will go from there. Okay. Friends, court is back in session. We are now back in front of the jury. And defense, it is your case. I ask that you kindly proceed.
Yes, Your Honor. Before we call our first witness, we'd like to make a motion before the court.
In front of the jury or at sidebar, counsel?
Sidebar, Your Honor.
Real briefly, go right ahead.
Yes, Your Honor. At this time, the defense moves for a judgment as a matter of law. Since the plaintiff has been fully heard and all the evidence viewed in a light most favorable to the non-moving party, that being the plaintiff in this situation, we believe they have failed to provide sufficient facts such that a reasonable jury could find for the plaintiffs on element 2 and element 4 of the required elements for them to prove in today's case.
Which are?
Yes, Your Honor. Those elements are that the defendant intentionally or recklessly caused the death of Lou Donaldson, and that intentional or reckless activity was the cause of the plaintiff's damages in today's case.
I'm only going to address the one. Would somebody from plaintiff's side give me a one sentence why you believe you have proved to survive this motion that defendant caused the death?
I'll give you 3 words, Your Honor. Preponderance of the evidence.
No, that's not an answer, and that was 4 words.
Okay, well, I will say that we have the burden of preponderance of the evidence. This can go to the jury because they simply need to find that by a preponderance of the evidence.
You're not listening to my question. Tell me what fact you have proved that a jury could conclude
Yes, Your Honor. We've provided evidence today that Karen Baja had every motive to kill her husband, and therefore it should go to the jury to decide that.
Okay. So respectfully, if motive evidence were the only evidence, I would grant this motion, but I actually think you presented something more, that you presented an opinion that wasn't objected to, that this was a homicide, and you presented exotic Bob. So for those reasons, Mr. Hobbs, and also because I'd be fired if I did it otherwise, the objection is, the motion is denied. We will now go back in front of the jury, and it is time for you to present your witness, please.
Yes, Your Honor. At this time, the defense would call Chris Renard to the stand.
Okay. Thank you. Mr. Renard, you've been sworn. Please keep your voice loud and clear.
Yes, Your Honor.
Investigator Renard, could you please introduce yourself to the members of the jury?
Hi, good evening. My name is Chris Renard.
And Investigator, why are you here today?
I am here today because I work for Summit Life Insurance Company, and I looked into the facts regarding the will and Mr. Lou Donaldson's disappearance.
And why did you look into those facts?
Well, I looked into those facts because as an employee with the insurance company, that's what I was asked to do by the CEO, to make sure that we should, in fact, be paying out on this claim.
Were you hired by Ms. Beja for this investigation?
No, I only work for the insurance company.
And were you able to, without going into the details of that conclusion, were you able to come to a conclusion as to those requests made by the CEO of Summit Life Insurance?
Yes, I was.
Before we get to those conclusions, I want to give the jury was there an objection? I'm sorry.
No.
Just trying to make sure we're all good here. So just before we go into your conclusions today for the members of the jury, I just want to cover some of your educational background. Could you tell the members of the jury how long you've been working at Summit Life Insurance?
Yeah, I've been at Summit Life Insurance for over 20 years now.
And what did you do before that?
I worked at the Statesville Bureau of Investigation in the crime lab.
And what were you doing in that crime lab?
Yeah, I was a forensic document examiner.
And before you were working in the crime lab here in the state, did you receive any sort of education?
Yeah, I have my bachelor's degree in criminology, and I also went to the Statesville Police Academy prior to going to the crime lab.
Now, you just mentioned that you're a forensic document examiner. Do you keep up to date with any certifications for that particular skill set?
Yes, of course. I'm certified by the Board of Forensic Document Examiners and the Association of Certified Fraud Specialists. Those are the two active certifications I carry in my role today.
Now, let's move to what you reviewed for today's case. What were you able to review?
Well, I was able to review the life insurance policy, the last will and testament that was presented by Ms. Baja, and I was able to glean some information from contacts I had with the police department.
And were you able to apply the methods that you were taught both in your criminology degree as well as your years of experience to those facts and data for today's case?
Yes, of course.
And are those the same principles or methods that are relied upon by other experts in your field?
Yeah, absolutely.
And would it be helpful for the members of the jury in today's case for you to use those principles and method in explaining how you came to your conclusion?
Yeah, I think so.
At this time, Your Honor, the defense would tender investigator here, Chris Renard, as an expert in both forensic document examination as well as a claims investigator for Summit Life Insurance Company.
So I got the first part, an expert in handwriting and documents.
Yes, Your Honor.
What does an expert in claims investigation have to do with this case?
Yes, Your Honor. As part of the investigator's opinion in today's case, he was required to investigate as to whether Ms. Beja killed Mr. Donaldson or Lou Donaldson in today's case. Because of that, and because of his job as a life insurance investigator for Summit Life Insurance, he has to review the possible events surrounding the death of a policyholder to ensure that there was no foul play involved, to know.
Okay. Do you have any questions on voir dire of the qualifications, Ms. Maxwell?
Yes, Your Honor. Permission to voir dire?
On qualifications, go right ahead.
Now, Mr. Renard, you have a bachelor's in criminology, correct?
Yes.
But you don't have any further formal education in investigations.
No, that's not true. I actually did receive I'm training from the Statesville Police Academy, which certainly covers investigations.
But no formal degrees.
Yeah, that's right. No other degrees.
And you don't have any accreditations regarding homicide investigation at all?
No.
Or missing person investigations?
No.
And you aren't the member of any professional associations in the field of claims investigation, are you?
No.
You don't hold any licenses in that field?
That's true.
You haven't been published in that field?
No, I haven't.
There is no board certifying you in this area?
That's true.
And you've never been qualified to testify in court as an expert in that area either?
I mean, I've testified in court, 25 times regarding, forensic document examination in my role as a claims adjudicator with the Statesville Life Insurance Company.
Please don't talk over each other.
I apologize, Your Honor. Mr. Renard, I understand. I'm so sorry.
Anything more on qualifications?
No, Your Honor, but at this time, I would object to him being tendered as a claims specialist expert.
Response, Your Honor.
Very briefly, 2 sentences.
Yes, Your Honor. This expert has 20 years of experience investigating claims, and that's all the experience he needs to come to conclusions as to whether a claim should be paid out or not.
On qualifications, Ms. Maxwell, your objection is overruled. As to whether that opinion is relevant or proper in this case, we'll cross that bridge when we get there. The witness is accepted as an expert in the 2 fields Mr. Hobbs proffered. Counsel, proceed.
Yes, Your Honor. Now that we've gotten your qualifications out of the way, Investigator Renard, could you please tell the members of the jury what your conclusions were for today's case?
Yes, I was able to reach 2 conclusions. First is that Ms. Baja did not kill her husband or cause his disappearance.
Objection, Your Honor. This is an improper opinion for a claims specialist or forensic document examiner to make.
Response, Your Honor.
I'm going to respond. Ms. Maxwell, isn't this the same stuff you had your expert talking about? Yes or no?
He was investigating the homicide, not a claims investigation, but I understand Your Honor's response.
Based on sauce for the goose is now sauce for the gander. That objection is overruled. Let's get to the opinions. You may proceed, Mr. Hobbs.
Yes, Your Honor. Mr. Renard, could you please repeat those 2 conclusions for the members of the jury?
Yeah, first I was able to conclude that Ms. Baja did not kill her husband or cause his disappearance. And second, I was able to conclude, we've heard that the will was forged, and ultimately that was inconclusive, and we decided to pay it on the claim as Summit Life Insurance.
Now, based upon your years of experience in working with Summit Life Insurance, what is the default position the insurance company takes on paying out a claim?
Yeah, I'm sure people don't like to hear it, but the default position is to not pay claims, to investigate the validity of claims that come through our office.
Now, I want to go back and cover that first conclusion that you came to. What sort of information were you able to gather regarding whether or not Ms. Baja killed her husband?
Yes, I mean, I was able to gather that Ms. Baja had an alibi, that she was never listed as a suspect or charged as any crime by the Pioneer Sheriff's Office, and that there was no blood or DNA recovered, which would support that finding. So that's what I used to determine that Ms. Baja wasn't responsible.
And as far as you're aware, based upon what you've heard in court today, is there any record of the number of planes or the serial number of planes that Mr. Lou Donaldson owned?
Objection, compound question.
Overruled.
Back to my question, investigator. As far as you're aware, is there any record of any of the serial numbers of the planes that Lou Donaldson owned?
As far as I'm aware, there is not.
Now, I want to move on to the second conclusion that you came to in today's case, that regarding the validity of the will. First off, how important was this conclusion to your conclusion that the claim should be paid out?
it was key. I mean, ultimately, my conclusion regarding the validity of the will is the reason that this claim was paid. If I had, thought that this was a forgery, I would have recommended that, my company not pay the claim.
And now moving to what you reviewed, could you tell the members of the jury what it is that you looked at in coming to that second conclusion?
Yeah, absolutely. In order to do forensic document examination, we need to obtain, analyze, and compare handwriting samples. So I obtained some samples from Lou Donaldson that came from the life insurance policy that he had, signed with our office. I pulled his signature from the Department of Motor Vehicles when he signed for his driver's license. And I also had the purported signature on the will, which I evaluated.
And in comparing those signatures, what conclusion were you able to come to?
I was able. I mean, it was inconclusive. At best, and because I couldn't find definitive evidence of a forgery, that's why I recommended that we pay out.
And looking at that signature on the will, which we've seen in court today, what sorts of things can change a signature over time?
A variety of things. I mean, it can be, anything from the type of instrument that somebody's using to sign. If you were to use a pen versus a marker, obviously the strokes would be very different. Somebody's age, the health, and even the state of mind that somebody's in. It, wouldn't be uncommon that somebody's signature changes over time, or that they purposely, want to adopt a new style of writing.
And so overall, based upon both your review before today's case and what you've heard throughout today's trial, has your conclusion changed in any way?
No.
And what is that conclusion now that you've been here throughout today's trial?
My conclusion is that Mr. Donaldson didn't, in fact, sign the will.
All right. No further questions at this time, Your Honor.
Thank you. Ms. Maxwell, the floor is yours for cross.
Thank you, Your Honor. Mr. Renard, I just want to ask you a few questions about your investigation and analysis. You were assigned to investigate whether or not the defendant killed Mr. Donaldson, correct?
That was one of the things I was asked to look in, yes.
Right. So you'd agree that motive is an important factor in these types of investigations?
Yes.
And you'd agree that relationship issues can be a motive in violent crimes?
Sure. Yes.
When you conducted your investigation, you didn't look into any possible relationship issues between Mr. Donaldson and the defendant?
No, I was, purely working in my scope with the life insurance company as to whether or not we should pay out this claim.
So none of their relationship issues factored into your conclusions?
No.
Now, you also reviewed records from Mr. Donaldson's bank account in your investigation, did you not?
I did, yes.
And you noted that he didn't spend any money after August 17th, 2012.
That's true.
And you don't believe that he's alive and well on an island somewhere right now, do you?
I do not.
Now, I'd like to talk a little bit more about your investigation of the will specifically. Now, you talked about the wording of the will as being suspicious, correct?
Not so much that it's suspicious, it's just a phrase that I had never seen.
And you've investigated hundreds of wills over the course of your career.
That's true.
And none of them said, should I die or disappear?
True.
Now, you also analyzed the signature on the will.
Yes.
And you determined that the findings were inconclusive, right?
Yes.
And that it was possible that somebody had forged this signature.
Possible, but unlikely.
But possible.
Yes, but ultimately unlikely.
Now, you also looked into the witnesses of this will, correct?
I did.
And you spoke with the defendant regarding her signing the will?
I did.
You'd agree that it's not ideal for the beneficiary of a will to serve as a witness to its signing, right?
Not ideal, but permissible under the law.
Right. It's not technically illegal, but somebody else would be better, correct?
Well, it's not illegal at all. And I don't know if somebody else would be better. It's just that, there could be a bias there that, certainly we should consider.
Right, a bias because they would benefit from the will being executed.
That's true.
Giving them a motive to lie.
Potentially.
Now, you also looked into the second witness of this will, correct?
Yes.
Miss Samantha Lane.
Yes.
And you spoke with her, correct?
Yeah, I interviewed her in person.
And she told you that she had seen Mr. Donaldson sign the will, right?
That's true.
But about a month later, you received a letter from Miss Lane.
I received a letter that purported to be Miss Lane.
Right. It had a signature on the bottom that said Miss Lane wrote it, right?
Yes.
Your Honor, best evidence?
Best evidence as to?
As to the content of this letter.
I'm not sure we're in content, so that objection is overruled.
Yes, Your Honor.
No. You'd recognize this letter if I showed it to you today.
Yeah, I would.
Now, I'm referring opposing counsel and the witness to what has been previously marked as Exhibit 8. And let me know whenever you have that in front of you, Mr. Renard.
Yeah, sorry, if you could just give me one moment, I will get there.
Take your time.
Got it, I'm looking at it.
Perfect. Now, you recognize this.
Yes.
You recognize it because it was the letter that you received a month after you spoke to Miss Lane.
That's true.
It's in the same or substantially similar condition to when you last saw it.
Yes.
The plaintiff moves what has been previously marked as Exhibit 8 into evidence as Plaintiff's 7.
Mr. Hobbs, this is what you just made the original writings objection to.
Yes, Your Honor.
Okay. It's admitted.
Now, Mr. Renard, in this letter, Miss Lane, to your verification of that letter in just a moment, but let's talk about the contents first. So this letter says that Miss Lane was not being truthful to you whenever you last spoke.
Yes.
It says that she was coerced into signing the will.
Yes.
Now, whenever you received this letter, you didn't initially try to reach out to Miss Lane.
No, I actually, and we kind of went out of order. I contacted Ms. Baja as the second witness, to look at the validity. Ms. Baja confirmed that she witnessed it, and I tried to contact Ms. Lane and was never able to find her.
So that's a yes. You didn't initially contact Miss Lane after you received this letter.
No, I used my 20 years of training and experience first to get to that point.
You used your 20 years of experience to contact somebody else instead of Miss Lane after this letter was received.
Yes, it would be common in my field to look for this separate witness. That could certainly be crucial evidence, and I confirmed that she did see Mr. Donaldson sign.
So after you spoke to the defendant about this letter, or excuse me, when you spoke to the defendant about this letter, you told her about its contents, right?
Generally.
Generally, you told her that Miss Lane had reported that she was coerced into signing the will.
I told her that I received a letter that I could not verify whether or not it was Miss Lane, and generally what the contents of this purported signature from Miss Lane and what it said.
Well, after you spoke to the defendant, then you tried to contact Miss Lane, as you stated, right?
Yeah, absolutely.
And you tried multiple avenues.
Yes.
And you weren't able to reach her.
That's true.
And as we sit here today, you haven't been able to reach her since you received this letter, right?
That's true. I never heard from Miss Lane again.
And like you said, you determined at that point that you could not possibly authenticate this letter and determine who it came from, right?
Yes, that's true.
But this letter has a signature on it, right?
Yes.
And it was in your possession.
Yes.
And the will that Mr. Donaldson purportedly signed, it was also in your possession.
Yes.
And coerced or not, there's no dispute that Samantha Lane herself signed that will.
Yeah, Miss Lane did tell me that she signed the will.
So you're an expert in handwriting analysis and forensic document examination.
Yes.
It's a big part of your job.
Yes.
It's why you're here testifying today?
Yeah, I assume so, yes.
But you didn't perform a handwriting analysis to determine if this signature matched the one that Miss Lane signed on the will?
No, because we couldn't verify that this signature, who this actually came from. And that's, not what I was asked to do. So no, I didn't.
Now, your job is to authenticate documents, yes?
Regarding Statesville Life Insurance Company and our payout on claims, yes.
So it's your opinion that this letter doesn't go to the authenticity of the will?
No, I disregarded this letter because I was not able to verify it came from Miss Lane.
But if this letter was authentic, it would be affirmative evidence that this will was fraudulent, correct?
I mean, I think that's better for the lawyers to decide. I mean, I think that this would be, conflicting evidence at best, counsel. Miss Lane told me in person that she signed the will.
Well, Mr. Renard, if this letter was authentic and says that she was not telling the truth when she told you that, that would be affirmative evidence that the will is fraudulent. Yes?
I think we'd have conflicting evidence. I don't know how I would reconcile the fact that she originally told me. I was there and I absolutely saw Mr. Lou Donaldson sign the will. So it's something that we'd want to investigate if that's the point you're making.
But you didn't investigate it by conducting a handwriting analysis.
No, I couldn't find Miss Lane. I would have loved for her to reach out and get some further clarification.
No further questions, Your Honor.
Thank you. Mr. Hobbs, any redirect, sir?
Yes, Your Honor. Now, investigator, I want to turn your attention to something that the plaintiff mentioned on their cross-examination. Do you still have that bank statement in front of you today?
If you give me 1 sec, I can pull it up. I'm sorry, I clicked out of it. All right, I have the bank statement.
And Your Honor, permission to publish that bank statement again to the jury?
Ms. Maxwell, it's admitted, correct?
Yes, Your Honor.
Fine, then go right ahead. If it's admitted, you may publish.
So I want to direct your attention, investigator, to the last line on this bank statement. Based upon what you've heard here today, who was responsible for ensuring that the animals had a correct amount of supplies?
Lou Donaldson and maybe Cam Donaldson.
And based upon Cam's testimony today, were you able to confirm whether it was Cam or Lou?
Based on Cam's testimony, I was able to confirm. I mean, I think Cam testified that she did everything, so I can imagine there could be instances in which she did it. But this record, shows that Lou Donaldson purchased animal supplies.
So if somebody were purchasing animal supplies with this debit card, would you be able to conclude who was using that card?
No, not necessarily.
No further questions at this time, Your Honor.
Thank you. Thank you, Mr. Renard. You're excused. Does the defense have any other evidence?
Yes, Your Honor. At this time, we call Karen Beja to the stand.
Wonderful. Thank you, Ms. Beja. I'm waiting for you to appear. Here we are. Thank you, Ms. Beja. Counsel, when you're ready, you may proceed.
Yes, Your Honor. Good evening. Will you please introduce yourself to the jury?
Yes, my name is Karen Beja.
What do you do for a living, Ms. Beja?
I have dedicated my life to the animals at Wild Wildlife, Tiger and Big Cat Emporium. My husband Lou and I both owned Wild Wildlife, and we had such a passion for those big cats and to preserve them in our sanctuary from harm.
Why are you here today?
I'm here today because Cam has brought this lawsuit against me.
Let's begin by talking about your relationship with Lou Donaldson. How did you meet your husband?
I actually met my husband when I was hitchhiking along the side of the road here in Pioneer. He pulled over and he picked me up and swept me off my feet, and the rest is history.
How was your marriage with Mr. Donaldson?
Our marriage, it was good. I mean, we spent a lot of time together. We liked to fish together a lot. We were business partners. But of course, like all marriages, we did have our problems.
What were some of those problems in your marriage?
Really, I can only pinpoint 2 big problems. One problem was that Lou was secretive. He liked to leave at the drop of a hat, whether he was going on a business trip or some other matter. He would just suddenly up and leave.
You mentioned that there were 2 problems in your marriage. What was the other one?
So the other one kind of stems from that first one of him being secretive. I found out that Lou had a mistress in Costa Rica.
How did you find out that he had a mistress?
Lou told me.
After this conversation about this mistress, how did your relationship with Mr. Donaldson continue?
I mean, right when I found out, the relationship, of course, wasn't that great because naturally I responded very poorly. I mean, he was my husband, and to find out that my husband was cheating on me, I took it very harshly, as you can imagine. We fought about it. I said some things that I didn't mean, but after that, we had talked about it and we were working through it.
Let me turn your attention away from your husband to your relationship with Cam. How do you and Cam get along?
So Cam and I don't really get along that well. As we heard today, Cam is definitely not I'm not Cam's biggest fan. He's not mine. I can't say that I hate Cam, but I definitely do not trust Cam.
Earlier today, we heard Cam say that you were Lou's mistress. As his spouse, what really happened?
Yeah, I have no idea what Cam's talking about with that. I was not Lou's mistress.
All right, let's transition away from Cam to Lou's disappearance. When was the last time in 2012 that you saw Lou?
Well, I know that I did not see him for a while, for a certain time period, but I know now that he went missing on August 18th, 2012.
Okay, then let's focus our attention around that weekend of the 18th. Where were you the morning of the 18th?
The morning of the 18th, it was actually very early morning. I was at Wild Wildlife at about 3 o'clock in the morning.
Why were you at Wild Wildlife at 3 o'clock in the morning?
So there was this tiger that had cubs, and the mother tiger had rejected her baby cubs. So I was there taking care of them.
What happened while you were taking care of these cubs, Miss Beja?
While I was taking care of these cubs, I realized that I had ran out of milk and formula.
What did you do when you realized that?
After I realized that, I knew that I had to run to the store and get more. So that's what I did.
What happened at the store?
Well, when I got there, I went in, I got my groceries, and then I came back out, but my car wouldn't start.
What did you do when you realized your car wouldn't start?
When my car wouldn't start, I knew that I had to do something, so I flagged down somebody to try to use their phone because I had forgot mine at home when I left.
Why did you forget your phone, Miss Beja?
I was just so tired. I was in a rush to hurry up and go to the store and get the milk and the formula and to get back. So just in the rush out of the house, I just left it.
All right, just a moment ago, you said you had to try and flag somebody down. How did that go?
I was able to flag somebody down, and they let me use their phone.
Who did you call?
I ended up calling my brother to come get me. He is a deputy sheriff at the Pioneer County Police Department, so I knew he was on duty that night and he was out and about, or patrol duty, excuse me, so I knew he was out.
Miss Beja, why did you call your brother instead of your husband?
Well, like I said, I knew my brother was already out and about, so I figured he was the best bet. And like I mentioned earlier, Lou was secretive. He goes on these business trips or other matters, and he suddenly gets up and leaves. And if he's on his plane or if he's gone, I can't reach him. And so I spoke earlier and I said that I hadn't seen him in a while. So I had just figured that he was on one of his trips and that I could not reach him.
All right, Miss Beja, just a moment ago, you said you called your brother. What happened after you called him?
After I called my brother, he did come to where I was and he checked out my car, but he took me home.
What happened later in the day on the 18th?
So later in that day, I ended up running into Cam at Wild Wildlife.
We've heard a lot about your run-in with Cam at Wild Wildlife today. As somebody who was there, tell us what happened.
So nothing happened. I just ran into Cam.
All right. Well, now that we've talked about the weekend, let's talk about what happened afterwards. What do you know personally about the police investigation?
all I know about the police investigation was that they eventually spoke to me and I gave them all the information I had. And the only information I had was he had a mistress in Costa Rica, so he could have been there.
All right, let's transition back from that weekend more to the present. Today, we got the opportunity to hear from a man named Exotic Bob. How do you know Exotic Bob?
Yeah, so I know Exotic Bob because I'm the reason that he is in prison. He was one of those, I mean, you heard him with those illegal deals with cats, and there was a case where I brought, and that's why he's in prison. And he clearly hates me for that reason.
All right, now that we've just clarified a little bit about who Exotic Bob was, let's turn our attention to the will. We've heard a lot about a will too today. What do you know about Lou Donaldson's will?
All I know is that it was Lou's will, and I was a witness to the will.
Was this the first time that you ever inherited anything from Lou Donaldson?
I mean, I was a beneficiary to his life insurance policy as well.
All right. Just to be clear, what involvement did you have in Mr. Donaldson's disappearance?
None whatsoever. Lou was my husband, and even though we had our problems, I still loved him, so I would have no hand in his disappearance.
No further questions at this time, Your Honor.
Forgive me. Thank you very much, Ms. Arroyo. Ms. Posey, do you wish to cross?
Yes. Hold on one second.
I got it then. I got the second yes. Thank you.
Okay, I'll just stick to this microphone so we don't have any issues. I apologize.
And it's on and it's working.
Now, Ms. Beja, I'd like to talk to you about this mistress that your husband had in Costa Rica. You stated that he was pretty secretive about that.
I said that he was a pretty secretive person in general.
Right, he was secretive about pretty much everything, including this mistress, besides you knowing that she existed.
Yeah, he was secretive about multiple things, including the mistress.
Ms. Beja, I'm going to ask you to speak up. I can't hear you very well. I'm not sure if anyone else is having the same issue.
I said that he was secretive about multiple things, including the mistress, but I did say he told me about it, so.
He would take off at a moment's notice.
There were times, yes.
He had several planes.
Yes, he did.
And you said that he went to see this mistress in Costa Rica.
I think he did.
But you don't have any proof that this mistress existed.
Lou told me that she did.
Well, you don't have letters or phone calls between them.
Nope, just going off my husband's word.
And you don't have, you don't know her name?
No, and I didn't really care to.
Well, you don't know where she lives in Costa Rica.
I did not ask for Lou's mistress address, no.
Now, assuming this mistress existed, it's pretty normal for you not to hear from Lou whenever he would go off to see her.
I don't know what you're really referring to. I know that when he goes on business trips and other matters, I don't hear from him then.
Well, I'd like to talk about that mistress a little bit more. You called her that because your husband was cheating on her with you.
Yes.
And years ago, when you first met Mr. Donaldson, he was married to his wife still.
No.
It's your testimony today that Mr. Donaldson was not married to his wife and cheated on you, cheated on her with you?
That is my testimony.
Okay, Ms. Beja, I'll move on. Now, you inherited a total of $10 million.
Yes, well, I inherited $5 million from the will, and then I was the beneficiary for the $5 million life insurance policy.
Right, and you also inherited ownership of the sanctuary.
Yeah, I guess through the will.
You own the sanctuary now.
Yeah, I'm the only owner left. Who is the co-owner?
I'm sorry, Ms. Beja, if you could lean in, I'm still not hearing you very well.
Yes, so Lou and I are both owners, and since he's gone, I'm the only owner left.
You were not an owner before that will gave you the ownership.
No, Lou and I were co-owners before the will.
You don't have a, Miss Beja, you don't have a deed here today for that jury to see the truth of the statement you just made that you were in fact a co-owner.
I did not bring a deed with me today.
And it's your testimony today that that deed exists, though.
No, I didn't say there was a deed. I just said that we were both co-owners of Wild Wildlife.
Ms. Beja, your statement just now is that you don't have that deed with you right now. So it exists?
I do not have a deed. We were just co-owners.
I understand. And you agree that a huge issue.
Sidebar, improper impeachment.
Not impeaching, Your Honor. I'm just asking a question to clarify. Your Honor, your mic's off.
Your Honor.
I apologize. I do that so that I'm not creating ambient noise. The objection is overruled. Go ahead with the cross.
Now, Ms. Beja, you'd agree that a huge issue in today's case is exactly what you got from Lou Donaldson when he disappeared.
Yeah, well, I mean, this is a wrongful death case, so I guess part of that maybe, yeah.
And you're aware that Cam Donaldson is alleging that she is the rightful owner and you are not.
I did hear Cam say that.
Okay. Now, you were a witness to Mr. Donaldson signing his will.
Yes, I was.
Another of those witnesses was Samantha Lane.
Yes, Samantha Lane was.
Neither you nor your investigator, Mr. Renard, could get in touch with Samantha Lane to be here today to testify.
I did not try because I don't think that that's my job to get in touch with people to testify here.
Ms. Beja, again, you would agree that you are the defendant in today's case, and Samantha Lane would be a pretty important person to this will.
If you say so, yes.
Well, Ms. Beja, if Ms. Lane was here today, she could flat out say whether or not she signed that will.
Objection, sidebar, speculation.
Well, objection sustained, argumentative. You've made your point, Ms. Posey. Kindly move along.
Yes, Your Honor. Now, your husband created that will on June 14th of 2012?
Yes.
And at the time, your marriage wasn't that great.
We were working through some things. It wasn't the best, no.
Well, at that time, when the will was signed, June 14th, just 2 days prior, your husband took out a restraining order against you.
He did attempt to get a temporary restraining order. It looked bad, but like I said, we were working through things and the temporary restraining order was denied. So no, there was never one taken out against me.
Well, regardless of whether or not it was approved or denied, Mr. Donaldson filed that saying that he was fearful of you.
Yes, that's what the document said.
That he wanted a divorce from you.
That's what the document said, yes.
And then 2 days later, he supposedly wrote this will granting you everything.
He didn't supposedly write it, he did write it.
Okay, and you're the only person he left all of his assets to.
I was his wife, yes.
Well, he didn't leave anything to his daughter, whom he'd known longer than he knew you.
Well, yes.
Objection, argumentative.
Sustained. Your points made, Ms. Posey.
Yes, Your Honor.
All left to the wife.
Yes, Your Honor. Now, Ms. Beja, I'd like to talk about that alibi that you had from the evening. You claim that you went to the grocery store. I'm sorry.
We're having trouble hearing you again, Ms. Beja. I must ask you to be closer to the mic. Thank you so much.
I did go to the grocery store.
And that was at 3 a.m.?
Yes.
And that was to go buy milk for your new tiger cubs?
Yes.
You don't have a receipt from that today?
I do not have the receipt, no.
You were buying milk for the tiger cubs, so that would be called a business expense.
Sure, yeah, I guess so.
And as you state, you are a very important part of Mr. Donaldson's business, so you understand that it's important to keep business receipts in order to make a business pretty functional.
Objection, sidebar, compound question.
Overruled.
Ms. Beja, if you'll answer my question, please, I can repeat it if you need me to.
Yes, can you please repeat it?
She was asking, in a business, is it important to keep receipts?
Yeah, it's important.
That receipt could have completely supported your alibi this evening.
Well, sure, but at the time, this is not an, at the time there was no alibi. It's just what I was doing. So I didn't, in the rush of back and forth, if I lost the receipt, I didn't think it was such a terrible thing because I didn't realize that this would be the case today, like this happened.
That's a yes, that there is no receipt for this jury to see today.
I told you that there was no receipt.
Now, further about that alibi, you said that your car broke down?
Yes.
And that you flagged down a passerby?
Yes.
You didn't call your husband?
No, I called my brother.
You didn't even call roadside assistance?
No, I called my brother to take me home. I needed to get back home to get to the Cubs. Okay,
well, let's talk about your brother then. You stated before that Wild Wildlife has a meat grinder on site.
Objection, Your Honor. Sidebar 403 and 401.
Overruled. But I don't know what you mean by before, Miss Posey. Do you mean today?
She's previously testified that there's
No, today. Do you mean in the courtroom today?
I don't mean that she said it today, no.
Okay, then ask her not what she said before. Ask your question.
Yes, Your Honor. Yes, Your Honor. Ms. Beja, there is a large meat grinder on the property of Wild Wildlife.
Yes, it's how we grind up meats to feed to the cats, or the big cats.
And you'd recognize a photo of that meat grinder today?
Sure.
Okay. I'm referring the witness as well as opposing counsel to what was previously marked as Exhibit 11. Ms. Beja, if you're able to pull that up in front of you, just let me know when you're ready.
Yes, I will pull that up. Okay.
Now, you recognize this?
Yes.
You recognize this as the meat grinder on the site of Wild Wildlife?
Yes.
And this is a fair and accurate picture of that meat grinder?
Yes.
Your Honor, we move into evidence what was previously marked as Exhibit 11 as Plaintiff 7.
Ms. Arroyo, any objection?
Yes, Your Honor. 401 and 403.
I overrule it on 401 at sidebar. Why isn't this unfairly prejudicial? They know she has a meat grinder, Ms. Posey. Why do they need to see it?
Your Honor, in just a moment, I'm going to be asking Ms. Beja about what she's already testified before, which is that this meat grinder can in fact fit a person. She's here for a wrongful death suit. This goes directly to whether or not she had the means to kill her husband and dispose of his body.
So at the moment, I'm going to admit it, not have you publish it, but ask the question. If she disagrees with you, go to town.
Yes, Your Honor. And to clarify, if we get through this, may I publish afterwards?
I don't know that you'll need it.
Okay.
Let's see what she says.
I understand, Your Honor.
Let's go back in front of the jury. Go right ahead.
Yes, Your Honor. Now, Ms. Beja, this meat grinder is pretty large.
Most meat grinders are, yes.
And you guessed that a body could be disposed in this.
Objection, speculation.
Overruled. Or I will show the picture.
Ms. Beja, I'll repeat my question. You guessed that this would be big enough to fit a body.
When I was asked about that on my deposition, I said, I guess, sure, yeah.
Right, and it would take 2 people.
Yeah, I think I said that. I've never done it, so probably, I guess. I don't know.
And you testified a minute ago that your brother picked you up whenever you called him that evening?
Yes, he picked me up and took me home.
And he brought you back to Wild Wildlife, back to your tiger cubs.
Yes.
Your brother works for the sheriff's office.
Yes, he does. He's a deputy sheriff.
Right, he's a deputy sheriff at the same office that investigated your husband's disappearance.
Yes.
Permission to publish that photo, Your Honor.
I'm reversing myself now. Given the equivocal answers, you may publish it briefly. Ask one question. Oh, that's better. Take it down.
That's all we needed, Your Honor. Sorry about that. Now, Ms. Baja, you fired Ms. Donaldson from Wild Wildlife.
No, I didn't.
Well, you said you didn't trust her.
I did not trust her, but I never said that I fired her.
Well, you didn't want her working with you.
I don't know if I said that either.
Is it your testimony today that you said that you didn't trust her and that you didn't want her working with you, Ms. Baja?
No, I said I didn't trust her.
Okay, I'll move on, Ms. Baja. Now, you said that the reason that you were out all night and that your entire alibi circles around the fact that these tiger cubs had been delivered.
I said the tiger cubs were delivered. I don't think I said my alibi circles around it.
I understand, Ms. Baja, but the reason that you were out that evening is because those tigers were born.
Yes, I have clarified that.
And you needed to go out and get supplies to nourish those tigers.
Yeah, I've said this a couple times now.
And Ms. Baja, typically whenever a tiger is pregnant, you have plenty of time to prepare.
I mean, depending on what you have to prepare for the giving birth, sure. Not all tigers reject their cubs, and that was the major problem why I had to do this. And you can't really prepare for a tiger to reject their cubs because you don't know.
You know that typically cubs need milk, whether it's from the mother or not.
Typically they need milk from the mother, yes.
But you have to be prepared for any situation.
I mean, sure.
And you'd been doing this presumably 11 years since your husband brought you into this business.
Yeah.
So you probably have refrigerators on site to store that milk.
We do have, we have some refrigerators and they store a bunch of different things. And I'm sure there was milk in some of them. Cam was the one in charge of getting the supplies and filling them, but that night there was none.
I understand, Ms. Baja, but my question was that you have refrigerators. That's all I asked.
And she responded, yes.
Now, Ms. Baja, about your relationship with Mr. Donaldson and how it began, he did not move in with you. You moved in with him.
Yeah, I did.
You had nothing when you met him. You were, we could say, pretty poor.
Yes, I mean, I came from a humbled upbringing.
And he didn't leave his business for you.
I'm not sure what you mean.
He remained working at the business where he worked after you met him.
Wild Wildlife, when we co-owned it, yes.
You weren't a co-owner when you first met Mr. Donaldson, Ms. Baja.
Well, no, after.
My question is simply, he did not get rid of his business when he met you.
No, there wasn't, no.
And he didn't leave his daughter when he met you.
No, I'm kind of just confused by your questions.
Well, you're insinuating today, Ms. Baja, that your husband had this mistress and he left you, his business, his daughter, everything for it. But he's done this before, Ms. Baja, and he didn't have to do that when he met you.
Counsel, we don't give speeches. Do you have a question?
Your Honor, Ms. Baja wasn't understanding my question, so I had to give her whatever she needed to understand it.
Counsel, ask a question.
Ms. Baja, he did not leave his business or his daughter or his home when he first met you. He brought you into those instead.
Correct.
And I'd like to talk about this supposed mistress and your allegation that he ran away to Costa Rica to see her. It was you that originally brought this to the police.
Objection, Your Honor. Sidebar, counsel testifying as to something the witness has not said.
Your Honor, the witness did say this, that she brought it to the police's attention that he had a mistress in Costa Rica, on direct.
That is not the statement to which I am referring. She said as to her allegation that Lou left her for a mistress in Costa Rica, she simply said that this was a possibility because he had reported about this affair at some time But she never alleged Lou actually went there or that she has any knowledge as to what Lou did.
I will rephrase my question to possibility, Your Honor.
Thank
Now, you said it was a possibility that your husband ran away to Costa Rica, and that was what you reported to the police.
Yeah, I mean, I didn't have anything else to tell him when he was gone for so long. That's the only thing I could think of, that he may be.
And you're aware that Costa Rica is about 2,200 miles away from Statesville.
Yes.
And that's not typically a trip that anyone would make in 24 hours.
He may not have made it.
Objection. Sidebar.
Yes, ma'am.
Speculation.
We don't know enough that this witness knows about airplanes or how
Your
much
Honor, if I
gas they
may.
use.
That's not what I'm asking. She simply has said that he used to take off to see her all the time, so she knows how long that trip would take from the time he left to when she saw him the next time.
Oh, I didn't understand your question that way. Is your question?
Rephrase it.
Is your question when he would go in the past, would he be gone for more than 24 hours?
Yes,
I
Your
thought you were
Honor.
talking about how long it took for the flight.
I'll rephrase, Your Honor.
Thank you.
Ms. Beja, when Mr. Donaldson would fly off to see his supposed mistress in Costa Rica, he wouldn't be back within 24 hours.
I mean, he would go off on business trips and other matters. I'm assuming maybe one of them would be Costa Rica, but there were various times that he would be gone for maybe 24 hours, maybe a week. There were a couple days. I can't tell you that about just that one 24-hour period.
No further questions, Your Honor.
Any redirect, Ms. Arroyo?
Yes, Your Honor. Briefly.
Please go right ahead.
Will you please explain for the jury some of your responsibilities while you were at Wild Wildlife?
I basically did anything and everything that Lou would have needed because we were co-owners. Anything that popped up, just like the Tiger Cubs, that's something that I would take care of just because it is my business. I was passionate about it, so I did anything I could.
Ms. Beja, one more thing. You were here a moment ago when Cam Donaldson testified, and you heard her talk about her responsibilities. What did you understand were her responsibilities?
Objection, Your Honor, by the scope of cross.
Scope of cross is about who had responsibilities for all sorts of stuff. Overruled.
Ms. Beja, just so we're clear on the question, you heard Cam testify earlier as to her responsibilities. What was your understanding of Cam's responsibilities based on that testimony?
My understanding based on that testimony was that Cam knew that she was to take care of the little administrative tasks for Lou, such as like office stuff. But yeah.
No further questions, Ms. Beja.
Thank you. Ms. Beja, you may step down. Does the defense have any further evidence? Does the defense have any further evidence?
Yes, Your Honor. We have one other witness to call today by deposition, that being the sister or the brother of Miss Beja, Carl Bannister.
Okay, you produce that.
Your Honor, just briefly, I apologize for interrupting. Could we get a quick time check?
Well, he's using his time, so let's get, oh, but you may have to cross or something, sure.
Yes, Your Honor.
May I ask that our time checker advises of the time?
Just one moment, Your Honor. We're calculating that right now.
Thank you so kindly. In the meantime, Mr. Hobbs, so I know, how will you intend to present the deposition?
Yes, Your Honor. I will be asking the questions that are presented in this deposition, and my co-counsel, Jordan Arroyo, will be answering those questions on the part of Mr. Bannister.
All right. And Mr. Maxwell, I assume that if there are additional questions read that you feel need to be read, you're going to want to read them and have those answers read?
Yes, Your Honor.
Got it. All right. As soon as you get the time check, we can proceed. Actually, you know what? Let's proceed with the direct. We'll get that time check before we start your cross so that you know how to do it. In the interest of time, please go ahead.
Yes, Your Honor. Mr. Roy, I'm going to have you look about 3/4 of the way down the first page, starting with the question, okay, let me ask you about that night. Are you there?
Yes, I am.
All right. Question. Okay, let me ask you about the night, well, early morning hours of August 18th, 2012. Do you remember that pre-dawn time?
Yes, I do.
Question. How do you remember it?
I was on duty that night, graveyard shift. So from 12 a.m. to 8 o'clock a.m.
Question. What do you remember about that time?
Well, it was a normal sort of shift. I was just answering patrol calls when I got a personal call from Karen.
Question. When was that?
Answer. It was close to 3 o'clock a.m. She had gone out to the grocery store late that night in order to get some milk.
Objection. Hearsay.
Let me hear the rest of the answer, please. Continue.
Answer. She had gone out to the grocery store late that night in order to get some milk or something for some newborn tiger cubs. She had car trouble and needed a ride home as soon as possible to get back to the cubs.
The objection's overruled.
Question. Did you go to pick her up?
Answer. Yes, I did.
Question. Did you use your patrol car?
Answer. Yes, she was actually in my patrol area.
We're going to skip down here. So you were very close to her location.
Answer. Yeah, I guess.
Question. Where did you meet with her?
Answer. Her car was on the side of the road a couple blocks away from the grocery store.
Question. How close was this to her home?
Answer. A couple of miles at the most.
Question. Was she going to or coming back from the grocery store?
Answer. I believe she was coming back as she had some groceries with her.
Question. How was she doing when you met up with her?
Answer. She was fine. She was just really concerned about those newborn cubs and wanted to get back to them as soon as possible.
Question. Did you drive her back to her home?
Answer. I first took a look at her car and it wouldn't start. So I made sure that it was safe by the side of the road and then took her home. We got to her house around 3:45 a.m., definitely before 4 o'clock a.m.
Now, Mr. Royal, I'm going to be moving to the third page. There should be a bold text on this page that says examination by Mr. Keys. I'm going to start with a question directly underneath that. Question, Deputy Bannister, how was your relationship with Mr. Donaldson?
Answer, it was fine. He did some great things for my sister, helping her find her passion for animals, big cats in particular, but he could be difficult.
Question, what do you mean by that?
Answer, well, he was moody at times and suspicious of people. He seemed paranoid. He would go off to Central America for extended periods of time and not want to talk about what he was doing down there.
Question, were you worried about your sister and her relationship with Mr. Donaldson?
Answer, I'm always concerned for my sister because I love her. She's family. But I tried to keep out of their personal relationship as it was not any of my business.
No further questions at this time, Your Honor.
May I ask our timekeeper to interject? Do we have the remaining time available for plaintiff?
Yes, Your Honor. We have 7 minutes remaining for the plaintiff and 26 minutes remaining for the defense.
And that's including for closing argument, yes?
That is 7 minutes for closing arguments, Your Honor.
Ms. Maxwell, understanding that dilemma, do you wish to read anything else of the brother's deposition or not?
I do not, Your Honor.
Most understandable. Okay. Is there anything else from the defense?
Your Honor, yes. We would like to renew our motion for judgment as a matter of law pursuant to Rule 50B.
And my answer is, for the same reason as previously, this strikes me as a jury case, but thank you.
Yes, Your Honor.
Counsel, you guys have been doing a lot of hard work, and I know we want to wind this up. Literally a 2-minute break to set up yourselves, both of you who are closing, set up your rooms. I'm literally checking my watch. In 2 minutes, we will start the closings.
Your Honor, I don't want to interject, but if the plaintiff wants, like, I don't know if they'll want a time check during their closing or as far as telling them that there's like a minute remaining or something like that. if they do, just ask that they tell us before they start, and we can either interject or put something in the chat, whatever they prefer.
Ms. Maxwell, do you have some sort of clock device where you can tell that yourself?
Yes, Your Honor, I'll time myself with that.
Okay, we're happy to do it also for you. I don't know which is less intrusive.
I'll do it by myself, but if I run over, feel free to interject.
Well, unfortunately, if you run over, I have to stop you, my friend, okay? All right, now it's a 1 minute break, but you guys get yourselves ready, please.
Yes, Your Honor.
I want to make sure everyone is back. Mr. Hobbs, you are handling the closing also?
Yes, Your Honor.
Got it. Okay. I'll ask everyone except the two arguers to, thank you, turn off their cameras. I guess we start with plaintiff. Is that correct?
Yes, Your Honor.
Counsel, good luck. The floor is yours.
May it please the court, counsel, members of the jury. We are here today because Lou Donaldson is not. Lou Donaldson is not here today because of the defendant. We know that Mr. Donaldson was killed by the defendant. We heard some evidence suggesting exactly how she may have done it, but the truth is, we weren't there. And she obviously isn't going to tell us exactly what happened to his body. So we don't know the exact details of the last moments of Mr. Donaldson's life, but we know that he died at the hands of the defendant. And we know she didn't stop there. Instead, she proceeded to oust his daughter from the family business, destroy his previous last will and testament, and forge and coerce her way into getting everything Mr. Donaldson owned. Now, soon you'll get a verdict form, and you'll be given the power to put an end to the 8 years of misery that Ms. Donaldson has suffered at the hands of the defendant, knowing that her father's entire legacy was under the control of his murderer. But for you to be able to exercise that power and serve that justice today, there are a few things that we needed to prove to you by a preponderance of the evidence. Now, the judge will talk to you soon and explain exactly what that means, but it's not complicated. If something has been proven by a preponderance of the evidence, that simply means you believe it is more likely than not that it's true. So when you're weighing out the evidence that you've heard today, I want you to imagine a scale. And if there is even a feathers more on the plaintiff's side of that scale in your mind today, it's your duty to find the defendant liable. But after everything that we've heard today, the weight of the evidence against the defendant feels more like a 2-ton tiger than a feather. Now, the first thing that we needed to show you is that Mr. Donaldson is in fact deceased. Now, there's no dispute that Mr. Donaldson has not been seen since August 17th, 2012. And you heard on cross-examination when I asked their own investigator witness, he told you he doesn't buy the idea that Mr. Donaldson is alive and well on a beach somewhere in Costa Rica. That's because he's not. We saw his bank statement. His only pair of glasses and his keys were found right here in Statesville. He is no longer alive. Now, aside from there being no evidence that Mr. Donaldson did flee to Costa Rica, other than the defendant's claim, it also just doesn't make a lot of sense. Because if Mr. Donaldson wanted to leave his wife and go be with a woman in Costa Rica, he didn't need to do it in secret. He was a grown man. There is absolutely no reason he would have had to cut off all contact with his only daughter, leave the wealth he had built and the business he loved behind to do this. When he left his first wife to be with Miss Baja, he didn't stage a disappearance or fake his own death. He just did it. Now, that brings us to the next thing that we had to prove to you, that Miss Baja was involved in Mr. Donaldson's disappearance and that it was her intentional or reckless conduct that led to his death. Now, we have heard a lot of evidence about how and why the defendant killed her husband. Now, we heard that on August 17th, 2012 was the last day that Mr. Donaldson was seen. Less than 24 hours later, the defendant had reported him missing. And this is the same woman who sat on the stand today and told you that it was normal.
Facts on evidence. We've heard nothing today that Karen Beja was the person who reported her husband missing.
I've heard the objections. I'll let the jury's recollection govern.
Yes, Your Honor.
Ms. Maxwell, pick it up from there, please.
Now, less than 24 hours after Mr. Donaldson was last seen, you heard Cam Donaldson tell you that the defendant was the only one alleging that he was gone that time, and that is the day that police say he was reported missing. This is the same woman who told you on the stand today that it was normal for her not to know where her husband was, that he often took off at a moment's notice and traveled abroad. So if this is true, why would she have been so concerned just a few hours later to report him missing? And if she was so concerned about her husband, she didn't seem to be too terribly affected by it when she marched into work on Monday and fired his daughter from the business. Now, she denies that she did that, but why else would the plaintiff have told you that she lost her income that day? She lost her job that day. It's because the defendant fired her. And don't you think that if the defendant believed there was even a chance that Mr. Donaldson was going to return, he would have waited at least a few days before firing his daughter from the business? Now, that wasn't the only thing that we heard that points to the defendant's involvement in Mr. Donaldson's death today. Because we saw the restraining order that was filed against her 2 days before this alleged will was created. Now, we know that that will isn't valid because it just doesn't make sense that in 2 days, Mr. Donaldson would have gone from fearing for his life because of the defendant to suddenly disinheriting his daughter, the mother of his child, and deciding not to create a foundation for the sanctuary to give everything to this woman instead. And that restraining order is not the only evidence that we heard that solidified a pattern of violence and threats. Because you saw the Exotic Bob video, and you heard him tell you that Miss Baja had threatened to feed him to her cats, just like she did her husband. Now, these threats of feeding people to cats sound too horrific to be true, like something out of a bad Netflix show. But the defendant said today that the meat grinder on her property very well could process a human body. So we know how she did it, and we know all 10 million reasons why. Because after Mr. Donaldson was dead, the defendant received all of his real property, the business he owned, and a $5 million insurance payout. And there is no question that the economic gains that the defendant earned from her horrendous acts against Mr. Donaldson should be returned to the plaintiff. And there is no question that the emotional damage that she suffered should also be compensated for. Find her liable.
Ms. Maxwell, thank you so kindly. Mr. Hobbs, the floor is yours.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury. Rumors, reality, revenge. Those are the three things that my co-counsel told you to look out for throughout today's trial. To understand why we're here today, how those rumors conflict with the reality that we've been shown, and how those rumors stemmed from revenge. To understand all of this, I have to tell you a story. Members of the jury, when I got my very first job, I was working with a woman by the name of Alice. You see, Alice had been working at the same company for over 25 years. She had never received a demotion. She had always been complimented on her hard work and dedication. The only thing that Alice wanted in the world, the only thing she deserved, was a promotion. So she waited patiently for that day when suddenly an outside hire was brought in for the very position that she deserved and that she wanted so badly. At that point in time, Alice started to spread rumors. She started to say terrible things about the new hire. Soon enough, those rumors spread, and Alice knew that those rumors had nothing to do with reality. But soon enough, the new hire found herself in front of the boss, and she was asked to prove every single one of those rumors false. Members of the jury, that is exactly what we have seen throughout the entirety of today's trial. We have seen rumors, and we have seen those rumors crash into reality. And just like plaintiff's counsel said before you mere moments ago, it is they that have carried the burden throughout today's case. And they had to prove 4 things to you. They had to prove to you that Lou Donaldson is dead, that the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct. The plaintiff, Cam Donaldson, suffered injuries or damages or losses as a result of the death of Lou Donaldson. And that the defendant's conduct, either intentional or reckless, was the cause of the plaintiff's injuries and damages. And members of the jury, there are 2 of these claims today that the defense does not contest. Throughout today's trial, you've heard that Ms. Beja, she had Lou declared legally dead 5 years after his disappearance. And so we don't contest that today. We admit that that element has been reached. Members of the jury, there's a second element that the defense also concedes today has been met. And that's that the plaintiff, Cam, suffered damages, injuries, or losses as a result of the death of Lou Donaldson. There is not a single person in this courtroom today that has not dealt with the pain of personal loss. And each and every one of us knows that that pain is real. And that's why, of course, Cam losing his father is something that we know would cause each and every one of us injuries and damages. And that's why we also admit that this element has also been met today. So members of the jury, that leaves us with 2 other elements. And we're going to focus on that second element. You see, there are 3 things today, 3 threads that the plaintiff has attempted to use to tangle Ms. Beja in their web of rumors. You see, the first of those lines is that the will was fraudulent. The second one of those strings today was that Cam's rumors sought to envelop Karen completely in a web of things that Cam knew were not true. And finally, members of the jury, the final thread today is the denial of the alibi that we've heard today. So we're going to take those one at a time. We're going to go through them, and we're going to show you how the death of Lou Donaldson was not proven by a preponderance of the evidence to be caused by the defendant's intentional or reckless conduct. And members of the jury, that word cause is crucial in your determination today. So the first thing we're going to look at is the will. Members of the jury, throughout today's trial, we've heard about this will. We've heard that there may have been a previous will. And we've heard time and time again how this will gave everything to Karen. But I invite you, when you go back into the jury room today and you look at that will and you see, based upon that will, in connection with the reality that you've heard today, that Cam would neither have inherited wild life, nor would Cam have been entitled to a single penny of that life insurance policy. You see, when Miss Beja took the stand today, she told you that she and her husband were co-owners of wild life. Now, with his disappearance, the ownership passed to her, not via a will, but because that's just how businesses work. And members of the jury, you've also heard today that that insurance policy, the $5 million life insurance, that has not been contested today. It has not been contested once that Cam should have received any amount of that policy. And so we look at what the will actually does. And we're left with a question: what exactly was passed by this will? And the answer to that, members of the jury, is nothing. Nothing was passed via this will. There was no wild life to be passed. And there was no $5 million life insurance to be passed. And so then, just like that, the first thread has been cut. And so we move on to the second thread, and that is Cam's rumors. And you heard today that Cam herself was entangled by those rumors. When my co-counsel stood before you and asked Cam those questions, you heard today that even Cam couldn't get her story right. That even Cam couldn't separate fact from reality. But members of the jury, we are faced only with reality at the end of today's case. And the reality is that no one truly knows where Lou Donaldson is. In fact, you heard from both the plaintiff expert, our expert, and Cam herself that her father owned many planes. And no registry of those planes has been provided. And no witness today can tell you if a single one of those planes is missing. Furthermore, you heard from the plaintiff's very own expert that no investigation was done to determine if there had been a plane crash. Not even a simple Google search, members of the jury. And yet that expert would have us believe that that is a thorough investigation. Members of the jury, we know what the reality is. And so you see, even Cam could not escape the rumors that she spread. And so that thread is cut. And finally, we turn to the denial of the alibi. And you heard today from Miss Beja and her brother that all she was doing that evening was taking care of some tiger kittens. And that those tiger kittens needed to be fed. Members of the jury, no piece of evidence today, not a single one, has been presented to refute anything that was said as a part of that alibi. So members of the jury, that thread too is cut. Because of that, we know that the plaintiff has failed to meet their burden. In reality, every single argument that they've put forward to you today has been stripped away, and we are left with the truth. And because this element is not met, there's a domino effect. You see, if element 2 is not met, element 4 can also not be met. You see, if the death of Lou Donaldson was not caused by the defendant's intentional or reckless conduct, her conduct can also not have caused the plaintiff's injuries or damages, because that is the reason we are here today. This is a wrongful death suit. So what does that leave us with? That leaves us with 2 elements met and 2 elements not. Unfortunately, members of the jury, a tie in this situation does not go to the plaintiff. You see, they had to prove every single one of these elements today, and they have failed to do that. Throughout today's case, you've heard about rumors. You've heard about revenge, but now you're confronted with reality. And that reality is that you cannot find Ms. Beja liable. Thank you.
You're muted, Your Honor.
I don't think we have time. Do you have time left? So professionally, I would have loved to have heard it. Let me ask all 4 attorneys to join me back on the screen, and ask my scoring judges to please join us back on the screen.
Just want to apologize to everyone for moving with my camera open. I know that causes motion sickness for some people, and I don't want to be doing that.
Fine. All right. So first of all, I don't know about where you are, but it's late at night where I am. So I want to wrap you guys up because I know you get to do this again tomorrow. And we are not supposed to spend a lot of time doing anything except congratulating you. I'm just going to ask each of our scoring judges to introduce themselves. I think we're allowed to do that, or say what you do.
Okay. Hi, my name is Marina Parra. You all did a wonderful job. You must be exhausted. I'm a prosecutor in Chicago, so I do a fair amount of litigating myself. But everybody did a really nice job.
Right.
Yes, thank you.
Aaron? We cannot hear you yet, sir. Not yet. Try it now. Nope. Perhaps you can put in the chat who you are, and I'm so sorry we can't get your voice now. Okay, and I am a law professor, a former trial attorney, trial advocacy teacher. I just want to say thank you. I'm sorry if I was rough on some of you with motions, but I was trying to judge down the middle. I'm very impressed with your command of the case and everybody's poise, especially in this rather strange environment we find ourselves called virtual trials. So we have our jobs to do now. I'm going to say to those who are watching, thank you for watching.